Do you want to have control of the PowerPoint, or do you want one of us to control it for you?
Hi Charles, how's it going?
Doing well. How are you?
Doing well.
Good.
Wait, can you hear us?
I can. Can you hear me?
Yeah.
Yes, sir.
So do you want to have control of the PowerPoint, or do you want one of us to move for you?
I don't know how I would if you're going to display it there, unless I was sharing my screen. But I don't know. I'm happy for you to click it if you don't mind me. If you don't mind me, just hey, next slide, please.
Yeah, that's great.
That typically works.
Ruben, you sent me to the no?
No, I didn't.
Okay, I can log in, that's fine.
Thank you.
Perfect.
Okay, your usual stuff. I got a little cup.
You did. Well, I gave that back. It was in the dog food.
Oh, thank
It
you.
was in Shaddy's.
I was like, that looks
Yeah,
familiar.
it's all you. I figured you might be missing it.
Chance.
6:27. You're doing all right.
I got some of that from the Peonia Farm Producers Market. This woman named Kate is.
Did you
doing
send? I'm trying to log in. Thank you.
I'm doing the Rose one tonight. Totally random.
Pictures of how our existing drainage pattern is on Grand.
Yeah.
It's not good.
All of Fran or?
All of Grand.
Oh,
I guess the,
Just go find out.
yeah.
I know, I haven't responded yet.
You're here. Good.
If you don't think you can do it, I want to. So that's.
I heard they are.
We're
It was a free TV.
right on Grand Avenue with the end. Right here.
Yeah.
I think somebody.
It's
We followed the SUV. On a flatbed tow truck.
Oh.
We were heading to Delta. Oh, yeah, that's from the, it looked bad.
yeah.
Then the headlight bounced off the back. And I'm like, oh,
Don't join them.
Well, the firemen were there for like 20 minutes sweeping the road, getting all the trash up.
He was dropping fluids everywhere.
Yeah. This was bad. I wasn't on. I missed it. Good.
All right, it is 6:30. We'll call this meeting to order. If we could do the pledge, please. I pledge allegiance to the flag
Of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Could we have roll call, please?
Mayor Smith,
Here.
Mayor Pro Tem Valentine. Here. Trustee Gruner. Here. Trustee Kett.
Here.
Trustee Hunter.
Here.
Trustee Stelter.
Here.
Trustee Schwartz.
Here.
At the Planning Commission side, Chair Watson. Vice Chair Howe was out.
Right, we just heard she had to go to Delta for an emergency.
Uh,
Hannah is out of town.
Commissioner McCarthy's not here.
Right on.
Oh, there it is. Where's that response?
I think that's.
Is somebody on?
Somebody just-
On the planning commission?
I know trustee or Commissioner Watson was gonna do her best to phone in.
Okay, oh, so would we
I
know,
was just gonna send her a text,
Yeah.
ask her if she's.
right, if she got
Is that
on?
okay?
Yeah, because if somebody's on phone,
I can't see it.
Can't see it.
yeah, I can't,
That's Aaron Watson.
I can't ever read this.
Well, that's dark skies, right?
It says Aaron Watson.
Okay, so Suzanne, but if someone's on the phone, would we know about it through Zoom?
If they're watching by YouTube, we wouldn't, but if they're watching by Zoom, we would, we'd have to admit that.
What if they're not watching, if they're
So is
simply
that-
talking?
Is that the address on the agenda?
The phone number is the Zoom number, and that would show up as a, even it would just be a phone look instead of a picture.
There wasn't a phone number on the original agenda.
They're
She
used,
asked for the numbers, like the,
oh, good,
She got it.
yes, she did. She got it.
Well, let's hope she
can at least call
considers
in.
it, because she's very interested in this.
And also joining us on Zoom is our new town attorney, Mr. Buck.
We do have somebody that just phoned.
Be calling in. Yeah.
Okay.
Okay. So, great, okay,
So can we test? When I tried that, I couldn't raise my hand. Can we test to see if she can raise her hand?
yeah, I don't know.
Yeah, I don't know. Ms. Watson, can you hear us?
Can you unmute her?
Hello?
Okay,
Can you hear us?
Hello?
Yep, we hear you. Is this Chair Watson?
Yeah, you're kind of echoey.
and, do we know if Chair Watson can raise her hand through her phone? I know we've done the phone before, but it's been a long time ago.
So is that it?
What's the,
Looks like it was up.
can you hear me now?
Yes.
What's the keypad number to raise your hand? Is it 6 or is it, you know?
Six,
So if I'm gonna hit 6 and see what happens.
that's a good idea.
Does anything happen?
Star six.
Star 9.
Oh, good job.
What was that? I didn't catch that. Star?
Star 9. There it is.
Yeah, good.
Okay, good. So, Peter is not online or in Zoom?
No.
Okay, all right. Would somebody like to make a motion to approve the agenda?
I make a motion to approve the agenda.
Okay, have a second? Second. Okay, thank you. All in favor?
Aye.
Okay, thanks. So we will roll right into actions and presentations, and we will have, I believe Clay is going to present the discussion of the rules of procedure for the planning commission, including scheduling of commission meetings and agenda content. So with that, Clay, if you're comfortable, we will turn it over to you.
Sure. Yeah, and I'll apologize off the bat. I had the wrong date and time on the front stamp there, but I sent the wrong version. So what we're gonna start with is so this is kind of like an overall briefing regarding best courses of action. Obviously, there is, what can and can't be done, and then there is what should and should be done. Should and shouldn't be done. And I like to go into best practices. And so obviously this is our summer workshop on July 18th and not that date. So one of the main things to recognize for all members, including board advisory board members, commissioners, what have you, water board, typically, depending on if you have a franchise, et cetera. Anybody who is has an advisory role and or has a statutory role as a commissioner and or a trustee in the town is beholden to a separate set of rules because of your special position within the town. So if you go to the next slide for me, one of the main issues that I see kind of in and out of all the different towns and places I've represented is when members of a board have trouble transitioning from their role as a board member from their long-standing role as just a member of the community. That is important because as a board member, you've gone from this sitting to this official role, and it can be very it can be a little bit life altering because you do have to change the way you think and the way that you participate, especially obviously in meetings where you're participating as a trustee or a commissioner. I'm going to talk about the outsider insider mentality, the minority majority issues, the critic representative issue, and we'll get more into this. But then the single issue proponent versus understanding that you're a part of a decision-making body for a host of issues that kind of fit together versus just one person who might come into a role that has, I got on the board because I told the town I was going to, change the town in this particular manner. But that one single issue might not, be in line with the priorities of the vision, mission, and goals of the town at that time. So just kind of setting that out that, you have a commitment to lawful conduct and, different areas of due process, and you actually have a higher requirement and standard for your ethical practices. I think we're going to get more to that. So go ahead and go to the next slide. One of the things I do in this presentation is I know it very well, and so I might talk to something that seems redundant on the slides, but that's because I'm talking to my next slide based on another slide. So if I skip over something, it's not because I'm trying to skip over or get ahead. It's just because I've already kind of touched on it, and I don't want to waste your guys' time. So we kind of touched on a lot of this, but one thing you have to understand, the big takeaway here is that your oath to uphold the Constitution is paramount to your position as a trustee and or commissioner and or other board member. And one of the things you have to understand is that now your voice you're an important decision-making body, but each individual trustee and or commissioner is just one piece of that equation, and that if you can't sway a majority of the rest of your fellow trustees or commissioners, then your voice will slowly be drowned out, especially if you're not if you have like I talked about, if you have that single proponent mentality and or you have these very widely varying divergent viewpoints, especially when it comes to like a single point issue. Next slide, please. So this is just my fun little slide regarding just little takeaways here. You become a proponent and stewards of the town. Okay, you have your most critical function, which this is just Clay's opinion. This isn't, you're not going to find this in statute or anything else, but I think understanding that you have to be, as a body, a proponent of the town's interests and the town's assets. And an asset isn't just a fiduciary term. Asset is your infrastructure, what makes the town a town. It could also be your culture, and understanding that you want to have progress, but you want that progress to be done in a healthy way. And you also want to protect and make sure that your infrastructure and your assets are growing with whatever progress or whatever vision you have for your town. So, as I say the commission, but that could be also termed as the board or, a council. You're basically, you are the board of directors. This is just speaking of the board of trustees. You are the board of directors when it comes to the final decision-making authority for the town. So it is a very important role. I cannot overemphasize how, important it is to have a good cohesive board. And then I've already kind of talked about the town thing. What's your critical interest is the function of the town. So next slide, please. And at any point, I'm going to obviously be able to take questions at the end, but at any point also, if there's something that you just don't understand what I'm saying, or you wanted to ask a question, I'm fine with that. Interjecting with your own stories, etc., might help, but it could also be counterproductive, just based on our timeline here. But I'm open for interaction during the course of this. I don't want it to be like just me boringly talking to you. So just please feel free to speak up if you have any questions. So again, I'm on this role thing because it is so important. A lot of people seek public office because they don't like the way things are being run, and they want to come in and save the town and change it. However, that what I see often is that leads to that outsider insider mentality that I was talking about, where, well, I'm going to get on, I'm going to change it. However, one or two people with their own agendas aren't going to do much when it comes to making a big decision for the town or the board. Because if you bring in that mentality, you'll figure out really quickly that you're just one voice, and that you really have to try to persuade. And this can be done. I've seen it done very well, where somebody has an issue and they figure out why that issue is better or fits into the grand scheme of a whole bunch of other issues, and they're able to convince the other board members that you should take a different direction. I think that's fine. We want healthy debate. We want healthy public discussion. But the longer you hold on to that outsider insider mentality, the harder it is for you to really truly change over into your role and become a force multiplier for the board. Next slide, please. So I've already kind of talked about this. Does anybody have any questions about this kind of theme? I've already talked about the fractional powers, all this. I kind of get ahead of myself on this, but if there's no questions.
Trustee Bruner has his hand up. You can't probably see that. Go ahead.
Oh, sorry.
So can you elaborate a little bit between go along to get along and this becoming the ultimate insider?
I guess I don't. That's a pretty broad question. What would you like me to speak more on?
I feel self-conscious when this outsider mentality discussion comes up, because I'm here in after a hard-fought election with a slightly different viewpoint than most people. And what I hear being said is go along to get along, give up on your honest reasons for having differences. And it sounds like go along to get along to me, which I think is really important.
Yeah, okay. I understand that. So
I take a poll. Do the people on this board consider that I'm an obstructionist in our meetings when we make decisions?
That's not appropriate.
Okay, well, excuse me. Then let's just continue with it.
We're all here to listen to the same information. Thank you.
Okay.
Yeah, and I will say, Trustee Bruner, this is I want to answer your question, but I also want to say I don't have all the awareness of the elections and things like that. This is truly a canned semi tweaked, and I haven't changed it for Paonia at all. This is the one I use for Silverton. This is the one I use for Westcliff, Coal Creek, etc. And it's almost identical to the one that Sursa uses. This is not, individualized towards Paonia. And I'm sorry, I'm not, I don't recognize the background with what happened with the election. I'm certainly not, just so everyone knows, I am not, this is not a training for one person. This is a training for the whole board. And this is a training that I give every board in every town. And this is almost nearly the same training as Sursa. But to your question, Trustee Broner, I appreciate that. And it certainly is not. I get that question a lot, and I like it because it helps me kind of put into perspective what this is really about. What we're trying to, what the attorneys and the ethics counselors are trying to do is explain this idea that, you can come in, of course, with your own ideas. Maybe they're different than what the ideas have been on the board. And I think that's a healthy thing. I think I mentioned earlier that, it's healthy to have debate and different perspectives and viewpoints. And that's what on this slide that we're looking at, that's what the goal is, right? Is you want to be on the prevailing side. And sometimes that means you have to establish that side through debate and, public discussion. And that's what I was getting at, is that, you have to be able to, if you want to get a majority vote, every politician knows this, you have to be able to collaborate, work with other people, and you have to be able to build consensus that your idea is the best idea for, the reasons that you think it is, and you have to be able to articulate that. The idea, though, between the outsider and the insider is that if you are thinking about yourself as an individual, and you trying to get something done, and you trying to get this accomplished, and you trying to change the town, and if you flip that perspective, that'd be like I, then that's where we see issues, because an individual trustee can't do anything on their own. So this is not about go along to get along. This is about, hey, if you want something done and it's different, you have to just remember that this is a we. And if you're thinking about it as, hey, we need to figure out how to fix this problem, I have these ideas, and consensus build versus, versus individualized agenda. That's what really this is about. And so it isn't go along, get along. In fact, I think the healthiest boards that I've seen aren't making all unanimous decisions. They are having healthy debate. They are having good public discussion with multiple perspectives. And so I don't want any of you to think for a second that this is, some sort of individualized training, and or that, this is that I'm telling you should just do go with the flow, do what everybody else is doing. I think healthy debate and, public discussion is one of the critical aspects. This is a mindset sort of thing. Like, hey, remember that you can still think of the group as a we, versus thinking of just, of I, and get things done. That's all this is. This isn't a, hey, shut up and do what everybody else says. This is remember, you need to convince at least 3 other people of your position, in a respectful and collaborative way, or you're going to undermine your own ability to possibly sway the viewpoints of your other board members. So I hope that answers your question, Trustee Bruner. And if it does, I'm going to move on to the next slide. All right. So again, this is going towards your role. One of the big things that we miss, and that we have to understand about why we do certain things the way we do it, is because of our openness and transparency requirements, and which roll right into our due process. What we want is for the people and members of the town to know, hey, this is how this works. If I submit this application, it's going to go through this process. If my process is denied, I have this appeal right, and this is how it works. And I go from the planning commission, and if they approve my application, then I know, or if they disapprove my application, I know I can go to the Board of Trustees with an appeal. And you have this this kind of algorithm, so that it doesn't seem as if you're treating every application, say for zoning, as a case of first impression, and people don't know exactly what's going to happen, then they're going to feel as if they're being singled out because something was done differently this time than last time, and you're going to get these very fundamentally, very reasonably founded appeals of your decision making if you're not being open and transparent, going through the same process for everyone, and applying the same set of rules for everyone. So that's what this slide is all about. Pending questions, I'll move to the next slide. So here's where this is just talking about like your roles in the group, bettering the group, becoming a not a unanimous decision making body, but a kind of a team mentality, keeping the town's interest as the foremost goal in mind. So this is all stuff I've talked about. Your roles, obviously mutuality of respect is a big deal. Making sure that everybody has the same information. That's what that kind of builds on doing everything, in the public eye, having the same due process and processes in place for all the different necessities of administrating the business of a town. Next slide, please. So here's just, again, this is a good takeaway, and you guys will have this slide. A lot of these slides are kind of, the slides kind of build on it. We get to a final, the issues, but then I also try to, talk about some of the, the pitfalls and, what we do to fix it. So this is really just for you to kind of look at for a second. If you have any questions, please ask. I'll point out that, one of the things I see that I think is a big one is problem-based prescriptions. And that is like, you're trying to fix something based on a past situation. I always think it's important, especially when it comes to public hearings and quasi-judicial functions, that you're only responding to the evidence you have in front of you. The other issue is diffusion of authority, where again, this goes to your transparency and due process, where people don't understand what's happening because you seem to have too many different people, whether it's an individual or groups, making decisions that are redundant and or aren't reflective of what the other decision-making bodies are doing. So you can see some of the rest. The other one that I'm going to add to this eventually is a false dichotomy, which is coming up with, if it's not this, then it's that. It's hardly ever just two solutions. It's kind of like what Trustee Bruner said, like, go along to get along. If you're not for me, you're against me. Like that, I don't think that's a healthy thing, as pointed out. I think everybody should be, as a group, hey, you might not like my idea, but what other ideas out there? And if it's different, and there might be a third idea or fourth idea, and you guys, that's what that healthy public discussion is all about. Next slide, please. Here's where we get into some very interesting and and information that you really want this is to the individual, and this is to the board. Even though you're not technically an employee, and I know that you guys spend a ton of hours and time for, I don't know how much the trustees offhand get paid, but it's probably barely enough for your gas money to get to and from the board meetings. And so you truly are, you guys are public servants, and but the statutes will term you, give you the status, and then hold you accountable as if you're employees of the town. And the reason this comes into play is because you have what's called a scope of employment. And if you act outside of your scope of employment, you could be individually liable for your decision making, and or anything you say you're outside your scope of employment, but you're acting as an agent of the town. not only could you create liability for the town, you can create liability for yourself specifically. And that comes in the form of litigation, insurance issues, et cetera. If you can go to the next slide for me. I'm talking ahead again. So you are covered, just like a corporate board would be covered with not only with your insurance policies, but you're also covered under the CGIA, which limits the amount of exposure the town has for for any liability. So under the Immunity Act, there's only certain things that the town and individuals that have responsibility for. However, if you're outside the scope of your employment, you no longer get the benefit of the Immunity Act caps and the Immunity Act liabilities, meaning if somebody tries to sue the town, say for a tort action, the town isn't subject to that action. However, if an individual is acting outside the scope of their employment and they create a cause of action under a tort claim, you could be individually sued and could possibly be held financially and or criminally responsible, depending on the issue, for that action. So what the main thing to take away here is, look, if you're outside of your job description and you're doing something outside an authorization under law, charter, ordinance, or otherwise, you might be outside the scope of your employment. So go ahead and go to the next slide for me, please. Okay, so I kind of talked to this already. Basically, if you go to the last bullet point there, you need to be able to trace what we're doing to an authorization. What authority do we have to do this? That's why when I write ordinances or when you see resolutions, you have those whereas clauses whereas section 3123-101 allows the town to act to zone and all that, and the list goes on. But that's why you have those clauses that cite authority, because you want to show that, hey, you're not taking arbitrary action here, that you're acting within the scope of your authority as passed down to you as a board from the Colorado Constitution, state statutes, and your local ordinances. Next slide, please. So the easiest way to stay within your scope of employment is only acting and making decisions in certain in certain venues, and that is always going to be as a majority vote in a public meeting. As I'm sure you're aware as trustees, I am your attorney, and I'm the town's attorney, but you as the board are the decision-making body of the town. Thus, a majority decision on the board's part will direct me and staff as to how to go about doing business of the town. And so you have very broad authority as law and policymakers to control what is happening. If you're doing that outside of a public meeting, then you could probably, that's the first clue that you might be acting outside the scope of your employment, and you might be losing that liability protection. Okay, go ahead and go to the next slide, please. This is back to that we versus I. Be particularly cautious. Even if once a matter has been voted on, and say you're in the minority vote, then that's the decision of the body, right? And so if you then individually go about, you can still have an opinion, of course, but if you individually go about trying to undermine whatever actions are being taken, or maybe there's multiple examples, but typically what I've seen happen is somebody doesn't like, or a few people, like on a 4-3 vote, 3 people don't like that the town has made that decision, and they will go then individually and or as a smaller group and try to undermine and or obstruct that decision, you will be acting outside the scope of your employment in that case as well. So just remember, the we mentality is very important. You have your discussion, you make your decision, and then that decision is what action will be determinative by the staff, and that staff will have to go with a 4-3 decision the same way that they would, and implement that decision the same way they would as a 7-0 decision. And then of course again, liability. So there's certain decisions that once made affect people's personal property rights, for example. And after you've given, say you've passed or approved some sort of project, and that person starts taking action based on your approval, and meaning they start developing and they start excavating or whatever the case may be, and you change your mind. If you change your mind, you are going to be financially liable for and having to stop that person. So if you give someone a permit and you want to go back on it, and or someone had ex parte communications before the permit hearing or whatever it was, then and that decision ends up getting overturned, the town could be held liable for that. And if you're found to be acting outside the scope, you might be on the hook individually and be fiduciarily liable for that decision, meaning you're going to pay that person back whatever money they have out of pocket for relying on your decision. Next slide, please. I think I've beat this one up. Obviously, if you guys want to read that and ask any questions, but the idea here is every person was elected. Sounds to me like, based on some of the things said tonight, that the last election was might have been contentious, and you have constituents to answer to. That's fine. You can answer to your constituents, and you can be proactive for your voter base, and still be a productive member of the board without going into these individualized insider mentality sort of things that we see that can really undermine a board's cohesiveness and ability to get things done. Next slide, please.
Oh,
okay.
We have a question here. Trustee
Oh yeah,
Brewer,
go ahead.
So there have been cases in the past where some staff people provided permits for people to do things that were arguably contrary to ordinance. What does a trustee have to do? What do you do if that happens as a trustee?
If a staff is acting outside of the direction of the board,
if they were acting outside of ordinance.
If the staff is acting contrary to board direction or an ordinance, then the board has the power to do many things. I mean, you can have someone else on the staff if they're not listening to you, or if the relationship is completely broken down. You could have someone else on staff write a cease and desist order to the person has the permit. You can go through the reprimand process for that staff member. You can remove the staff member. I mean, there's all sorts of things you can do.
Okay. So should, when something like that happened in the past, a board member could have brought it up without jeopardizing their immunity because this permission has already been given. Sure.
I mean, it depends on what context, but in the question, I guess, if a staff member is acting outside of board direction, then you want to immediately bring it to the attention of, first, you would probably want to talk to the staff member, and then you want to put it as an agenda item and discuss whatever you think the issue is, or however either the staff was acting outside of the scope, or whether or not like a permit should have been issued. But typically, like I discussed, staff are not going to unilaterally make decisions. There's certain administrative things that the board has delegated down to staff through ordinances, resolutions, and some statutes allow advisory boards to make certain decisions, et cetera. But typically, the board, the staff will not be acting unilaterally, meaning without authority. And so, many questions that when I'm talking and we're going about our weekly business with staff, let's say, for example, this hasn't happened, but just as an example, Stefan might say, hey, we got this application. We want to make sure that we have the authority to do this. And then my role is to say, okay, yeah, let's look at this ordinance or the statute and make sure that what we're doing, we have the authority to do it. And if not, let's put this on as an issue for the board to discuss and give us direction on what they want us to do. And so that would just be an example of how, something like that might come about. And of course, if a trustee has an issue, they can always, bring it, the best process that I've seen is you say, hey, I think this is outside the scope, or this person is acting outside of their authority, or this person is, acting in defiance of the direction that was given by a majority vote of the board at the last meeting. And you have, you have the mayor as a chairperson add that to the agenda, and you deal with it accordingly. I rarely see staff that directly defies, board direction, if at all. I don't know if I've ever seen a staff member just say, I don't care what the board said, I'm going to do what I want to do, because good staff, and I do think, my relationship with staff, with this town and other towns has been that people want to do a good job. People want to do what the board asks of them. They don't want to do anything that would hurt the town. And certainly they don't want to do anything that would create personal liability for them. And so, I think that staff is typically just does what the board asks. But in the cases that they don't, there are definitely processes for that. And I'm happy to get involved with that if and when that would ever happen.
Yes.
Mr. Buckner, could I just ask for clarification between, what I heard Trustee Bruner asking is, what could an individual board member do rather than the board as a whole? And my understanding is, if an individual board member sees a problem with staff, then it should be brought to the mayor's attention to be placed on the agenda, so it can be discussed by the body as a whole rather than addressed by one individual trustee.
Right. Yeah. As an individual trustee, and even as the mayor, in a weak mayor form of government, the mayor and individual trustees do not have the power to reprimand staff, to fire staff, to hire staff, like everything. That's kind of why I start with that at the beginning. The whole we thing is, the board has to make that decision. And there's certain, especially with certain staff officers have statutory protections that disallow a board from reprimanding them and or giving certain directions without board authority and without proper notice, et cetera. And so, yeah, individually, a trustee, if they see something, obviously, if it's something like, if you have like a rogue staff issuing, building permits for 5-story buildings in a residential zone 1, there's certain things we can take quicker action with, including like filing injunctions, et cetera. And that would be like the worst, crazy case scenario where I'd have to get involved by, writing cease and desist orders or going through other staff and code enforcement to stop, like a rogue staff officer's decision to, grant permits outside the scope of the ordinance or something. But again, I've never come across that. If we were to come across that very rare circumstance, I would just have you call a special meeting and get me involved, and we would fix it from there. But again, an individual trustee wouldn't have the power to take any formal action on behalf of the town.
I see a hand up, and I'm assuming that's Chairman Watson.
Hello?
There you
Hello?
go ahead.
I heard the word weak mayor form of government. And I guess I really want to know what kind of form of government Paonia is, because I seem to remember the last time I heard, weren't we being called a strong mayor form, or am I wrong? During our
Yeah,
last
so
administration.
this gets confused a lot, but I'll tell you right now, I can count on my left hand the amount of how many cities or towns in the Colorado have a strong mayor form of government, and Paonia is not on that list. In order to become a strong mayor form of government, you have to go through a voting process. You know, you have to go through a petition, and a ballot, and a voting process, and become a strong mayor form of government. At that time, the mayor becomes kind of like a CEO of the town, wherein the mayor has not only the right as a voting member of the board, but they also have the power of hiring and firing and taking administrative action, et cetera. Only a few major cities and the entirety of Colorado have a strong mayor form of government. Just weak mayor, I don't like the term, but that's just what has come out through, statute is a weak mayor, which is pretty much the rest of the forms of government. And so you have to kind of think of government in layers. So there's strong mayor, weak mayor. Then there's amongst weak mayor, there's different structures, including like home rule versus statutory. And so, the best way to describe Paonia is a weak mayor, statutory, 7-member board town. So I kind of do it in layers in my mind, but just so you're aware, you're definitely not strong mayor unless I missed a very major, very major piece of the pie here in Paonia. But I can tell you're not on any list that anybody else is tracking as a strong mayor form of government, and you would know it because there would have been an election, and then there would have been a complete overhaul of the form of government that you have, including like every ordinance that you have. You would have been delegating power left and right by statute to the strong mayor. But in this case, weak mayor doesn't mean the mayor is weak. It just means that the mayor is just a single vote and that they don't have powers, administrative powers that the strong mayor form of government has outside of the voting power of the board as a whole. So that, you could write, there's like 30-page, legal journal articles about strong mayor versus weak mayor, but that's kind of it in a nutshell.
And if I can
Okay,
just
thank
add,
you. That's probably the clearest explanation I've heard in quite a while about what Paonia
thank
might
you.
be.
I'll take
Okay,
that as a
thank you.
compliment. Yeah.
Okay.
Clay, I just wanted to say I do not vote. I'm only a tie-breaking vote.
Okay, yeah. So that's a whole nother. That's like the fourth layer of the onion. So there you can do that as well, where basically at that point the board can decide what they want with how they want the mayor vote to count, either as a voting mayor or a veto power tie-breaking vote. And again, that's done through that's again separate from the form of government that you have. That's just one of those things. There's a statute that allows the town to grant the voting power to the mayor and then or vote to have the mayor be a tiebreaker veto vote only.
And that's what we've done in code.
And yeah, and you guys did that through, an ordinance some years ago, I presume.
Yes.
Yeah. And so, again, so people, that's where a lot of stuff gets confused. They're like, no, we took away the mayor's right to vote, so they're no longer a strong mayor. And that's not the case. The strong mayor they were never a strong mayor form. Again, I hate the strong versus weak, because I don't want anybody to think that I'm saying one thing about a mayor. So that the way the mayor is weak, it's just the verbiage that they use. But all that aside, yes, that's a completely different issue, but that is one of the issues that gets people. I've been to 3 or 4 towns now where I get there and they're like, no, we're strong mayor and we made the vote. And what they're referring to is just that they've given the mayor a vote and everything versus taking away the mayor's right to vote and just making them a tiebreaker. And that's a completely separate issue. But it's very confusing because I feel like a lot of times just boards just aren't given that information when they should have been. Like, hey, this is what you are, this is what you do. That's why I like to give this presentation as soon as possible especially after a new election, but also when I come into representing a town, I always bother staff until they let me give my little leadership best course of action brief, because it does elicit these sorts of questions, which I think are healthy for the board to understand. Pending any other questions, next slide, please. Okay, we're on. I need to get back to, there we go. Okay, public meetings, the chair. Okay, so this is just kind of a breakdown of like what, even as a weak mayor and even as a tie vote, the mayor still is and always the chair of the commission. So the mayor has a tough role to play because they're charged with controlling the scene. They're kind of like the judge in a courtroom. They're the ones who rip the gavel and make sure that people are acting appropriately, that you're following the agenda, that you are focusing on discussion. And I kind of liken it to an air traffic controller. Yes, okay, I recognize this person, you're free to land. Okay, now I recognize this person. Otherwise, especially with contentious issues, public meetings can very quickly devolve into just absolute chaos where, as a legislative body, you're not having any meaningful legislative discussion. And at what point, then there's really no point for you even to be there. And so keeping decorum and control over the room is really important. Next slide, please. Again, this is more, I won't spend a lot of time on this because it's really just centered towards the chair, but it's good for everybody to understand what the chair's role is, even if you're not that, because, for example, if the mayor is gone, Mayor Pro Tem becomes the chair. And if the mayor is gone and the Mayor Pro Tem is having to zoom in remotely, then I always suggest that somebody in the room acts as the chair. And then you just do that at the beginning of the meeting. And so any trustee might end up as the chair of a meeting. And so you should know, what your roles are and soliciting input, and then knowing when your input is, on a merry-go-round, you've heard everything you're going to hear. And, when it's time to just go ahead and put something to a vote. Next slide, please. So the previous slide and was really meant towards, that's why this says public hearings continue, but this is really the substance of the public hearing issue. So there's a big difference between public hearings and public testimony. I mean, public hearings and public meetings. Public hearings carry with it a kind of a quasi-judicial tone, wherein there is requirements that you have a requirement that you have public input. That's not what, and that's often confused as well. During a public meeting, the town will often solicit public discussion and public statements, but that is not required anywhere in the Constitution and or statute that you take public comment during just regular public meeting issues. You really are never required to take public comment and get public have public discussion, meaning from the public, unless it's an actual public hearing. And that's something that we'll learn more as we go, but just understand public hearings and public meetings are actually different. Next slide, please. So when you have a public hearing, again, that's when you're soliciting public discussion and or public comments. And again, we do that often during meetings because it's healthy, but during public hearings, it becomes not only the healthy thing to do, but the statutorily required thing to do, which elevates the importance of it. And so at the outset of a public hearing, what we'll often do is we'll specify in the agenda, hey, now we're going to go into a public hearing for this item. We are going to hear the applicant, we are going to hear the staff, and then we are going to take public comment. At the closing of those three presentations, we are going to have a discussion amongst the board, at which time, once discussion is completed, we're going to make a decision. And then, so you're telling and that, that was off the cuff, but something similar in different situations. And then you're telling the public, hey, this is what's going to happen. This is going to be your chance at input. And typically, even at a public hearing or taking public comment, it doesn't mean you have to have a back and forth with the public member. It just means you have to take the input from the public. However, it is healthy to have some discussion with people who have interest in a certain item, especially if it's a property right interest. Next slide, please. So this is a good way, like if you're trying to solicit more information from an applicant or somebody that you want to engage in the public process, in the public hearing process. I joke not to act like a U.S. Senate committee member where you kind of understand where people just ask a question or, just ask an impossible question with a false dichotomy just to try to make the person, seem like they're asking a dumb question or whatever. It's really important to really truly try to listen to comments and questions and react accordingly. Of course, you're never trying to debate or demean. You're really just trying to take in the information so that you can make the most informed decision. And then another thing, of course, during public hearings is to not have already have your mind made up. You're really supposed to be an objective party if and until up to when you're going to make that decision as a board, and that comes after your discussion. So try to stay as open as possible to all viewpoints, and then if you're open, then that's when that debate comes into play. Whereas if someone could sway your opinion, then if it's a 4-3 one way, and after public comments, healthy discussion, it might go 4-3 the other way. And so but whatever it is, you certainly don't want to have your mind made up at the beginning, and you certainly don't want to say anything that would prove that you've already had your mind made up, because that would be a violation of the purpose of a public hearing. Next slide. Okay, we're going to ratchet it up. So we know public meetings is kind of the standard. Then you have your public hearings, which have a little bit higher of a standard, not a standard of proof, but your standard of requirement for public input. And then you have quasi-judicial actions, which are probably one of the most important and conscripted things that you will do. And that's because these affect, typically, these are geared towards and affect people's personal property rights. So when somebody comes in and they say, I want a special use, or I want a variance, or it's going to affect their rights as a property owner specifically, a lot of that will trigger your quasi-judicial actions. So this is when we have kind of an elevated procedure, elevated due process, and we have elevated requirements for, it certainly is a public hearing, but it's actually even more than that. And so you do have rules of evidence, although they are informal, and I have scripts for this. So, towns have been like, well, I've never known what to do. This is quasi-judicial thing. So, a few years ago, I actually created my own template so that I could present that and give that to a board. And then, of course, based on whatever type of application it is, we tweak it so that it makes sense. And then you'll have like step one is presentation by the applicant. Step two is presentation by the staff. Step three is presentation by interested parties and anybody who wants to appeal, et cetera. And then this is also the time where we start talking about ex parte communications, et cetera. And I'll get to all this. This is just kind of your subject matter. We're switching gears here slide. So if you want to go to the next slide, please. So like I said, there's rules of evidence. Typically, what I tell people is, look, if it would affect your decision making, if it's in other words, if you think it's relevant, you can consider it. As board members, you can give weight to certain evidence. So even if board member says, I don't care about that, doesn't make any sense, I don't want to even, it doesn't matter. And another board member says, well, you know what, I would like to hear what this person has to say because I think it's relevant because of this. Then, if it has any any credibility for relevance, then I say just let the information come in, and then as board members in a quasi-judicial action, you're acting as judges, and you get to assign whatever weight you think that evidence carries, whether it's testimonial or pictorial or whatever type of evidence it is. You get to weigh the importance of that evidence in your decision-making process. We're not going to, I give the hearsay as an example. Like, hearsay is a very complicated evidentiary rule that comes into play mostly in criminal settings. I'm not going to go through. Hearsay has 7 rules in and of itself, and then multiple exceptions for each one of those rules. So as you can probably guess, it gets wildly complicated, subject to scrutiny, and even, you know, courts amongst different states disagree as to exactly how hearsay should be applied. So hearsay in our case is absolutely admissible. But we can, if you were to say like, well, I don't know, is that hearsay? And I say, yes, I think that is hearsay with no good exception. Then you might determine like, okay, we'll hear it, but you might decide then to give it less weight. So if it does break an evidentiary rule, my point is that it doesn't make it so that you don't consider it. It just makes it so that you might not consider it with as much weight as you otherwise would. And then of course you have to consider everything that's presented to you, and not have any prejudgment. Next slide, please. Ex parte. This is a good one. So I get a lot of ex parte questions because it's fun to say, and also because it's a really kind of, it's a simple concept that has very complex ramifications. So basically, if you have an applicant, say, we'll just go back to the special use permit. If somebody has submitted a special use permit, then, you know, staff would typically inform, you know, board through email or otherwise, like, hey, we have the special use permit, we have this other application that's going to have to go through a quasi-judicial function. Please do not engage with individual X because they're the applicant. And then you have, so you know and then we put on the agenda for, say, 6 weeks out, because we know we have to do 4 weeks notice, including mailers to surrounding interested parties, etc. 2 weeks later, you have a person that comes up to you and says, hey, Bob, I received this letter because I'm within 200 feet of this owner who wants to build this shop. And I know they're in a commercial space, but they really shouldn't be able to build this shop because it has, it's going to be too loud, and there's going to be people coming, and they're going to have to change. We do know that they can't get the amount of parking spots required by the zone, and they start trying to convince you. At that point, you know, your answer is, I'm sorry, I can't discuss this. I have to, you know, this is going to a hearing, and I can only make my decision based on the information I get in that hearing. If your response is, yeah, I know, I hate it too, I'm going to try to shut this down, then you might have just undermined the whole entire thing. For example, if you said that, and then it actually, even if you're in the minority and say that project did go through, that is still creating something that someone could challenge, that was not a true quasi-judicial function, that people had their minds made up beforehand. And even if you're in the minority and you lose, you're still creating liability for yourself, and you're creating liability for the town, because you might have to go through that entire process again. Something might have changed, and then you're on the hook for whatever monetary damages that person has in reliance on that initial decision. So just understand that this is a very important thing. Ex parte communications are one of the things that I see as a red flag and as a problem area. So once the application is received, you should not talk about an application with anyone, because you are going to be asked to be basically a sitting judge and make a determination at a future point, and you're supposed to have an objective viewpoint. When I was a judge, I was a municipal judge for Pagosa Springs for over a year, and you'd be surprised. And I was like, I'd been a prosecutor, I'd been a defense attorney, I'd done a lot of stuff. I'd been a magistrate in the U.S. military, but I was surprised at how much I did not know. And what that told me was that the Pagosa Municipal Court did a good job And people did a good job making sure that I was not given any information. Of course, I was not seeking that information, but my files were completely different than the files that the defense attorneys and the prosecutors and even the court staff had, because you don't want the judge to have any information or biases when they're making a decision. And so, the less you guys know, and the more surprised you are by information in a quasi-judicial hearing, the better off you are. Next slide, please.
There's a question from Trustee Bruder, Clay.
Oh, okay.
So, as far as being surprised, it seems like it's required for decision makers in a quasi-judicial setting to have a solid understanding of the law that's applicable to the decision. Is that correct?
Yeah, that's correct. And that would be done during a staff brief, where, at the beginning of a hearing, you'd have a staff presentation that says, like, here is, say, for example, you have a planning commission that's decided, yes, we're going to give you this permit, and then it's appealed or something like that, and you have to go to a quasi-judicial hearing. And at that meeting, at that hearing, the staff will have a staff presentation where they say, here's what the planning commission determined. Here is this section of the code that the applicant's permit falls under. Here is what the zoning law says about, whatever the issue is, the size, area, and location of the building, or how many stories it can have, or how many parking spaces it has to have. And they'll go through all those requirements and explain that this, in our opinion, we think this application meets the minimum requirements of the law, or it doesn't. And then you hear from, then you hear from input of the applicant and anybody who has an interest that might be for or against it. And then you discuss among yourselves, and discussion might look like, look, it meets the minimum requirements, but there might be a requirement that it fits in with the like the culture, not culture, but it fits in with the like if you have like a historical zone, for example, is where this comes up a lot, and you have a new building, and there's often argument where discretion is involved with does the building look historical and not out of place or whatever. If there's generic language used in your code, that's where I see these sorts of things become more problematic, because then you're talking about whether the planning commission or the board is acting as like the beauty police, or if they're acting as actual like applying the standards. And so I try to steer land use development codes away from saying whether or not something fits or is appropriate for the location. But yes, that is often the determination, and your staff will give you that when you're at the outset of a decision-making process, that yes, here's the ordinance that we're applying, here's the statutes that apply, and then you go about the discussion like we talked about.
Clay, so I'm both on the planning commission and I'm at the board of trustees. So as a planning commissioner, as the staff report is ultimately important to know the specifics about what's coming in front of us. When should the planning commission see that staff report? Before at the day of the hearing, or should it be in the agenda?
Yeah. So if the planning commission, and this is a great point. You're gonna hit on like 2 or 3 very contentious matters as it pertains to statutes and conflicts. So first, if the planning commission is acting in a quasi-judicial role, which does happen under statute in a few cases where the planning commission or it's been delegated to the planning commission by and through the authority of the board pursuant to statute, you have the planning commission that is acting just as if the board of trustees would on an appeal, meaning the planning commission is the quasi judicial body, and they have to abide by all these rules because they're going to a quasi judicial function. In that case, planning commissioners should not hear or have a staff report until the day of that quasi judicial hearing. They should not have any information. Now, that's not, I'm saying published, right? So if there's a staff report that's been put together and there's an agenda, you can publish that agenda and you can publish the evidence that's going into the agenda before the before that hearing, but it shouldn't be trustees and commissioners shouldn't try to collect information on their own, and that information really shouldn't be given much more than a few days in advance or what is reasonably necessary to review the packet ahead of the function, just to save time. Meaning there's no way, and what I would often say is like, look, you should probably publish this like on a Thursday or Friday if the quasi-judicial function is going to, or the quasi-judicial hearing is going to happen on a Monday. But that packet, you better be sure that that packet is what is going to be the official public packet. And then of course you don't know what people are going to say and what presentations are going to be made and how that staff packet is going to be supplemented by applicants, interested parties, et cetera. And so, yes, you could get the packet ahead of time, but that packet has to be completed, staff packet, and it really should be as close to the hearing as possible so that you're not having to supplement that packet. If you say, for example, you put it out 2 weeks in advance, there could be a lot more information that could be gathered and or events that occur between there where you're constantly just changing the packet, because that means you have to republish it so that everybody else has the same packet. So anyway,
if I can interrupt a second, because we are seeing the agenda packets for the planning commission quite a bit ahead of the meeting, because we are seeing everything the applicant submitted. That's all. We're not seeing the staff report. We're seeing everything that's in the public realm as part of their application. Is that appropriate to do 3 weeks ahead of time so anybody who's interested can see everything that we're going to see ahead of time?
Yeah, so there's a big difference between like an application that requires a public meeting or a public hearing and determination versus a quasi-judicial function. Typically with a quasi-judicial function, you're dealing with an appeal or some other action that you're making a determination against conflicting interests, whether that interest is an appeal from a planning commission decision, et cetera. But for your typical actions, even those that require a public hearing, you're often going to see an agenda packet 2 weeks in advance. Probably if you're on a 2 week cycle, I'd say 2 weeks in advance is about right. And of course the application is public, right? So there's certain things that are getting put into an evidentiary, like your evidentiary packet for quasi-judicial matter, that are just already matter of public record and don't have to be kept secret. That's what I kind of liken it to like what a judge would take judicial notice of, right? Like, well, you don't have to wait to understand, or, I don't have to pass any sort of evidentiary ruling to get the judge to recognize an ordinance or a law that's in existence. You guys get to look at matters of public record, ordinances that are in existence. Like it's really kind of more of a common sense rule where if anybody else knew it or could see it, then you can know it and see it, but you just can't go about trying to get the information yourself.
Right.
Does that make sense?
Yes, it does. And it sounds like what we are doing is what we are supposed to be doing. We are seeing everything that the person who's going to come in front of us for quasi-judicial has submitted into the public record. And then it's my responsibility to look at code and get myself familiar with what exactly the code is associated with that particular issue. But we don't see the staff report or anything that is considered private for whatever reason. We would not see that till the meeting. At the meeting, like the staff report sometimes would be handed at the meeting.
Yeah, and sometimes a few days in advance, if there's any. Again, this is all done not every hearing, meeting, and quasi judicial function is exactly the same, because there are different processes that trigger the requirements of say, for example, of a public hearing, but that might have a different process. For example, like submitting an application for a permit versus an appeal of a denial of a zoning change. They're going to be different just because the substance of the issue itself is different. But yes, from what I've seen, you guys have done it the right way. I haven't seen any issues with that.
Okay, hang on, let me, thank you. And trustee Stelter had his hand up, and then Stefan. So trustee Stelter and Suzanne is after trustee Stelter, sorry.
I just have a clarification. If we have the staff report early, does that mean that it excludes any additions to the staff report? Because that's testimony.
I'm gonna give you the lawyer answer. It depends. And so what ends up happening, for example, is it really depends on the type of quasi judicial hearing you're having. What an appeal, for example, you're going to get a staff report, say on a planning commission, you're going to get a staff report. They're going to tell you what they think about the application. You're going to have that staff report and the application. And then you might get an appeal from an interested third party, for example, which would have to go to the board of trustees because they're challenging the decision of the planning commission because they've been noticed, they have a right to, they're an interested party, and by statute, they can force an appeal. A neighbor, for example. Now, all of a sudden, that has changed the game because the next staff report for that hearing is going to be completely different than the one that was presented by, not on behalf of the applicant, but in conjunction with the application. That staff report, you don't know what they're going to say. You don't know if whatever information that the appellant has brought has changed the staff member's mind, or if they're going to be on the side of the planning commission's decision, or if they're going to say, I disagree with the planning commission. So it really does change depending on what type of issue we're talking about. And that's why it's important to be in contact with staff and to have a decent, town attorney that can walk you through like when and where to do these things. And if I ever feel like, hey, we should not be giving this information, or, that might be considered ex parte, I'm going to say so. And I'll tell the staff that, and I'll tell trustee that, I'll tell a board member that. Like, I'm not going to be quiet about it. I'm going to, do my job and let you know. But that's really it depends answer.
Go ahead.
I do, Clay, I have a question on written comments. So, let's say after a quasi judicial agenda packet has been published, or we receive a written comment about an application in, should we wait until the day of the public hearing, or should we put comments into that packet as we get them? Should we wait to the day of the public hearing and then read those written comments? Somebody might not have been able to come and speak, or how should we go about doing that?
So public hearings, I think you want to put as much information in as you can. The trick with what I always say with the public hearing is, look, the public hearing has to do with public comment and public interaction. I think you can put emails into a packet, but I always advise that they don't carry much weight unless the person actually shows up to make the statement during the public hearing. You don't want to just be reading public comments and public emails into record as if the person was there stating it, because they're not there. We still have a basic right of due process, which also includes clarifying and or challenging what people have to say. And so written communication during a public hearing is very very low, has a very low meaning, at least to me. And that's the thing I advise boards is that, it doesn't, you can put it in the packet, that's fine, but it really shouldn't be a matter of consideration. You definitely shouldn't be reading it into the record as if the person was there. Now, when you're talking about quasi-judicial functions, even though I do still believe that emails and written materials or written statements have very little meaning absent a person actually being there to state them and or be challenged based on what they're saying, they could still amount to ex parte communications. So you should not be exchanging emails with an interested party or anyone when you're about to be sitting on going to a quasi-judicial hearing. But again, that's completely different from a public hearing, which is completely different from a public meeting. And that's why you want to have someone to kind of, advise you until you get the hang of, what and when, what type of meeting you're going to when all this matters, because, you're going to get emails a lot, as a political member of, or as a member of the legislative body, and they're not all ex parte communications. They only become ex parte communications when you're dealing with a quasi judicial matter that you're going to have to sit on and go into your judicial role versus your legislative role. You guys, I do not envy, you guys have so much to do, and you have so many different hats you have to wear. It's not always fun, but these rules are important.
As staff, can I receive emails? I'm not making a decision.
Yes.
Okay, Clay, Chairperson Watson has a question, and I just want to, before I open it up to you, Suzanne, I just want to say we're going to work closely with you, Clay. That's evident.
Sure.
On everything going on. Thank you. Chairperson Watson, go ahead.
Hi. So I have a question. What happens in a staff report if you see bad information? And for instance, with the zoning change and the wrong definition of C1 or C2 is included. Do I have, and when you see a report at the last minute and, you think something's wrong there, you say something, it's really hard to look things up to be more forceful with your, or assertive with your point that you make on that. But what is one to do? We're really dependent on the staff work, but what do we do? There are a lot of board members who don't know the code intimately and wouldn't even pick that up and would be swayed by something like that. Where's the responsibility there?
Yeah, well, certainly, staff has a responsibility to, do their best, but it's, we're all people and mistakes get made, and sometimes you do get bad information. And at that point, It's incumbent on you to point out that you believe this information is inaccurate, and that you should not be making your decision based on inaccurate information. Depending on the severity of the error, you might have to start the process over, or you could correct it on the spot, make sure that you're acting under the appropriate authority, and move on. When it comes again,
I think it's fairly minor sometimes, but the thing that's upsetting is when it appears again in the new report for the Board of Trustees, even after you've said something.
Yeah, I don't know what to tell you with that. That just
okay.
Obviously you don't.
But I just think there's a
responsibility
for staff too. Okay.
Oh no, the
Thank
staff
you.
has a responsibility to present information that's correct, of course. Again, it's sometimes people make mistakes. You might find in the future that I have an error, relied on an ordinance or something that has been repealed, or I've made some sort of mistake because of just the kind of the organic nature of local government. But at that point, you own your mistake. You say, "Yep," or always be open with each other, right, and have mutual respect, so that we can criticize each other and in a respectful way, and say, "Hey, I think this is wrong." And then if that person then has to do some due diligence and do their research, and if it is wrong, they need to correct it. Then they need to say, "Look, I gave you wrong information. Trustee Watson or Chairperson Watson has brought that to my attention, and I've changed it. And now, this is what I believe is the right authority. Thank you for correcting that." And then you move on. Obviously, if you bring something to light and it's not corrected, then that's a bigger issue that you should probably bring to a board, bring to a trustee, and then if again, if necessary, then we're back to that. What do we do with staff that aren't that are defying the direction of the board or an ordinance? And again, that, in my opinion, or at least in my experience, is very rare, and typically is most often it comes down to miscommunication or misunderstanding. Is rarely a staff member directly defying direction because, you know, as staff members, we all know that's our job. I don't,
Okay.
you know, but
So
that's
another
my
question is,
suggestion for that.
as far as being advisory somewhat as a staff, for instance, if a planning commission recommends a zoning change based on a future comprehensive plan, I mean, I don't know if that's actually correct, but wouldn't the staff maybe have an obligation to say, or to let the board know you need to disregard that recommendation because you can't base zoning decisions on future comprehensive plans that haven't been approved yet? I'm just kind of wondering about responsibility to see things done correctly. It's always been,
Sure.
you know.
Yeah, no, sorry, you kind of lost me with that example. I'm not tracking that.
Okay.
You know what you're asking me. I apologize, but
okay, just a zoning change based on approving of a zoning change based on the future comprehensive plan that we're now considering. Is that enough of a I don't see that. I always thought zoning changes are based on the one that you have in front of you, not the future comprehensive plan. That hasn't been approved yet.
That's a very.
And then I would think the staff would have a responsibility to say, no, you can't be doing that. But maybe I misunderstood.
My staff did only contemplate that existing comprehensive plan.
Right. Yeah. So Suzanne, I think we need to move on. Clay, any other questions from the?
Yeah, that just seemed. Yeah, and I'm sorry I can't answer that question. It's very specific, and I don't. It sounds like there might be some background there that I don't know, and I don't want to, wade into something that I don't really understand the context of.
If you want to move, well, we lost our Ruben. Can you continue slides? Can you hit another slide? Are you, Clay? Are there any more questions from the trustees? If not, we'll move to the next slide.
I apologize.
Okay, Trustee Bruner has a question. Wait, so hang on.
So we were on ex parte, and
yeah, we're on ex parte.
okay,
If you could go to the next slide, we're still on.
I tried to educate myself a little bit on ex parte, and I came to the Colorado Code of Judicial Conduct 2.9. Is that what this is actually based on?
No.
No?
I mean, loosely, yes, but you can't apply the judiciary requirement of ex parte communications to a quasi judicial function. I mean, everything we do is a little bit watered down from those levels that you're talking about. That's why when we talked about like the evidentiary stuff, I said, yeah, hearsay evidence is still allowed, but you might just give it less weight. Same thing with some ex parte stuff. The judiciary requirements are far more stringent than what would be required of a quasi judicial member.
Okay, so is there some equivalent to the Code of Conduct 2.9 that we can look at that spells this out?
There is and there isn't. So, that's where it kind of trickles down from. Most of this ex parte stuff at this level, or a lot of it at least, is a conglomerate of case law. So case law has a lot to do with a lot of the information that I'm giving you, meaning somebody said, it's been challenged and the courts have made a decision that, okay, this is what we would consider ex parte versus not, this is not ex parte. For example, one of the things we didn't get to, but that's really interesting between the Planning Commission and a Board of Trustees meeting. So this is like a clear example of my point here, sir. The statute requires that that a certain amount of members, typically of the Board of Trustees, are also on the Planning Commission, right? We're following that. The Planning Commission makes it then appealable. Say the Planning Commission's at a public hearing, they make a decision, it gets appealed, and now the Board of Trustees is the appellate authority, and it's been elevated to a quasi-judicial function. It almost, by statute, violates a very strict interpretation of ex parte communications under that judiciary rule, because you have already sat and determined, for example, like if you're on the Planning Commission and you're a trustee, you've already gotten a bunch of information that you might not have seen if you're just sitting as a trustee, and you've already been exposed to the applicant's point of view, the staff report, a bunch of information that you really shouldn't see that might technically be considered ex parte communications. But then you do have to act as an appellate authority as a trustee. We would, common sense would say, well, that's just that's a per se conflict or a per se, a violation, and that person can't also then be the appellate authority for a decision they made. But that's not what Colorado law has come down to. We kind of recognize this like very large gap between what is required, as a quasi judicial function, because we then make those appellate members of the trustees also sit on the planning commission and then let them sit as appellees. And so there's all these little caveats that make it, not I wouldn't say confusing, but that you just have to understand the rule and then understand there's a lot of exceptions. And that's one of those like widely, it's one of those exceptions that is like kind of just widely known to be pretty conflictory, but then also just accepted because it's I guess because it's just part of doing business in a small town, right? Like certain trustees are required to be on the board, on the planning commission. Their decisions can be appealed, and then they can also sit and appeal their own decision or sit as an appellate authority on their own decision. So there's some, it's not a perfect system, but it's it's a system we got, and I believe the best one in the world. But there's so many examples like that where you can't go to the handbook because it's more watered down than that. And there's been a lot of case law and interpretations to get us where we are today. So if you go to the next slide, this will actually kind of briefly talk about that. So for example, like a site visit, you never want like a judge wandering around the crime scene, right? Trying to make their own determination as to what happened. The burden of proof is on, the petitioner or the prosecutor. This is where the staff reports are interesting. You don't want to be contacting staff and saying like, hey, what about this and what about that? This better be in your report. You don't want to be, those are all considered ex parte communications. However, they might not be at a public hearing, but they definitely are at a quasi judicial function. And again, this is stuff you don't have to memorize. This stuff you don't have to I will walk you through this. I will help. The point is that when you are going to be once the trigger has been pulled and we know we're setting a quasi judicial hearing, we will notify you. Hey, this matter is going to become an issue at a quasi judicial hearing. Please do not have any contacts with anyone regarding the issues. You'll be presented a staff report, blah, 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 on this date. And this is the date that's going to happen, at which time we'll go through this particular process. And we'll walk you through all that.
So I've got a hand up, Trustee Schwartz. Go ahead.
Okay, so I have a question for you. What happens if ex parte contact has occurred? So let's say I engaged in it, it was found out. What do other trustees, like what obligations do we have? How do we remedy that? Whether the ex parte happened intentionally or unintentionally?
It depends on what part of the process. If it's at the outset of the process, you probably should recuse yourself. Well, first of all, you just don't participate in the ex parte communication to begin with. If you get an email, that doesn't mean you've committed an ex parte violation. If you read the email, then react to the email, that could be considered, an ex parte communication. You don't want to be going on site visits. These are all things that you can avoid. However, if you know someone is intentionally engaging in ex parte communications, and you realize that my point is that if you're intentionally doing this, you're probably not going to recuse either. If someone is known to be having ex parte communications, contacting staff, conducting their own site visits, you should bring it to the attention of the board, and the board needs to consider removing them from challenge. First of all, typically a public challenge isn't necessarily the way you do it, unless that particular trustee or commissioner is just refusing to recuse themselves, and you have to bring it up in a public setting, at which point you can basically vote to remove them from that particular decision, because otherwise what will happen is you're creating a challengeable offense, which means that no matter what decision you make, it could be challenged on the back end, and you might have to undo it and start all over anyway.
And you mean
So it
challenge?
depends on what point in the process, but
Clay, when you say challenge, do you mean by the person asking for the decision could then?
yeah, yeah, but you have to understand, like most of these issues that are quasi judicial, isn't just the applicant, right? So no matter who wins, there's going to be someone who's upset because there might be a third party interest. There might be an interested third party that doesn't want the applicant to get their permit, and there might be someone who does want the applicant to get their permit that didn't, and they don't get. You just never know who and how somebody could be affected. That's why it's so important to create this particular due process that is truly objective, that gives both sides the same right and input, so that you're not so that the person who knows the trustees better isn't winning. You have to create through transparency and trust and due process this truly quasi judicial function that is fair for everyone. And that's what all these things are geared towards. It's not trying to keep trustees or commissioners in the dark. It's not trying to make your job harder, although it does. It's really for the applicants and those people who might be future appellants of whatever decision that gets made, whether that's for or against the applicant. So that's what this is all about. And so you just keep that in mind. There is a purpose behind all this, and it's to keep you objective until you have to make a decision.
Any other questions? Hey.
Okay, so we talked about this, no site visits, contacts with staff, etc. Beat that to death. And again, I kind of already got to it, but I'll go through this really quickly. The whole idea, next slide, please, is we're avoiding prejudgment and bias, which again is different than ex parte, but ex parte plays a role in that. This is really self-explanatory. Next slide, please. So I'm not good. Again, this is the whole idea is that you want to be able to make a finding that if appealed, if the board of trustees is making a quasi judicial finding, you're subject to challenge in district court. So this isn't just, hey, this isn't like, this little kangaroo court thing. We're doing this for a reason, because any decision you make, if challenged, is going to be challenged in district court. And if there's any, if we've done something wrong as a body, the town might be liable. And if individual has done something wrong, that individual might be held liable. So the idea is that, we do the right thing. We have our process and we have our written findings. Next slide, please. So, and again, this will be all included. This would be included in your template, and I would walk you through all this. Here's what your options are. Next slide, please. We're on motions now. Okay, so I don't know how much we want to get into, because we've kind of been going a while. How much we want to get into parliamentarianism.
Could I interject? So it's
Please.
8:00, and one of the things we really need an answer to is who schedules planning commission meetings, who creates the agenda, where does that authority lie? That's been there's been a lot of confusion about that, and if you could give us a succinct instructions on that. I feel like it's 8:00, and I don't know that we need to go through parliamentary at this point, personally.
Sure. So motions, I'll skip over. Go to the next slide, because I was just about to get there.
Okay.
Motions, your roles and limits. Okay, this is more like specific stuff. Go to the next page. Okay. And I swear this slide was I did not make the slide for that question. This slide is it's always in the slide deck, and I do this for everyone. So this is just an example for like, for what we've been talking about for like roles and limits. So your specific question, and I'm going to just kind of use this slide to talk around your question. Your specific question was, whose role is it to create the planning commission agenda? Is that what you're asking?
Yes.
Okay, so in an environment where, so typically there's a lot of answers to that, but I think that there's no like statutory, here's who does it. The way I've seen it and what I think is the best course of action is that the planning commission agenda is built off of two things. What the, actions of the board, meaning, hey, the board delegates down to planning commission certain authorities. Please give us, the draft of what you want for, our comprehensive plan that's in accordance with our, greater mission, vision, and goals. Or it's driven by just their direct authorities through statute and application. So, hey, there's an application, statute says the application, or an ordinance says those applications goes to the Board of Adjustment and or to the Planning Commission. Obviously that gets put on the agenda, the next agenda that the staff can properly prepare for. So, and then of course there's notice requirements for certain things too. So say, for example, there's a 30-day notice requirement. Obviously you're not gonna be able to, for a certain application, for rezone or whatever it is, then you're obviously not gonna be able to have that meeting before that, but whatever that next agenda is, obviously that item would be on the agenda. Then of course you have the planning commission itself, its role obviously is an advisory, but there are certain authorities given to the planning commission. And, within those authorities, planning commission is always at liberty to discuss, say, for example, the board, the town has said, hey, planning commission, we want you to give us, we've got this question from this, I don't know, from a staff member, from a member of the public, please please give us your opinion as to whether or not this building would be within, outside of an application, please give us your opinion on this. At which point the planning commission could add that to their agenda or not, depending on what that meeting or their next meeting looks like. Same thing with like an ongoing issue. Say, a good one is the comprehensive plan. So if the planning commission is charged with coming up with a comprehensive plan, you don't have to wait for somebody from the board to say, hey, you should probably talk about step one of the comprehensive plan that's due in 6 months. The planning commission can, use its delegated authority to create agenda items based on what is asked of them from the Board of Trustees, if that makes sense. One thing I talked about way early on in the presentation, I can't remember exactly where it was, but that is making sure not to be acting like kind of, is the diffusion of authority. You want to make sure that your spheres of authority are clear, and so that you know who does what. And so I don't think it's a good course of action for advisory boards, boards of adjustment, planning commissions to have their own agendas that are completely unilateral and distinct from what the Board of Trustees is prioritizing, for the town. That's because you don't want the tail wagging the dog, so to speak. Planning commission, if they were setting their own agendas and making their own decisions on certain things, that might require a review and or approval and or a final decision by the board that the board has no interest in or has not delegated or has not asked of the planning commission to give them opinions. So, if you're creating these opinions for issues that the Board of Trustees is not even considering, you're just kind of spinning your wheels. And that goes back to, who's in charge, who's doing what. It's important, in my opinion, for the town to see that the Board of Trustees is the decision-making body for the town, and that everything else kind of runs off of that, because you guys are setting the priorities and the, you know, you're triaging issues, and you don't want the planning commission or a board of adjustments or any advisory board kind of just doing their own thing, because they could be affecting your time and your future agenda items that you don't even want on the agenda, for an example. So that's kind of my opinion on that. There's no statute that says planning commissions can't, you know, do certain things. It's just a matter of, you know, best course of action. And the healthiest thing I see is when a planning commission and the board of trustees are in cahoots, they're collaborating, and they're working in concert with each other to, you know, affect the administration of the town, especially, you know, in their particular roles. So I don't know how else to answer that, but you know, that's my opinion on that.
Questions? Yep, Trustee Bruner?
Yeah, I'll carry it a little further. What is it? Here in 31-23-208, the procedure of the commission. I think that's where it is. Yeah. So the planning commission adopts the master plan. And when the commission is ready. And so I would take this to mean that the commission has actually the responsibility to meet to discuss the master plan until the commission feels and makes a motion to adopt it, and then schedule the required legislative hearings and stuff. And then the board can actually formally have an adoption here. And it seems to me that the planning commission has by statute the responsibility to consider it and be ready to consider actual adoption before that is scheduled by some other part of the organization.
Yeah, I agree with you. I think so. What we're kind of really talking about is the implied tasks given to the planning commission, or, you know, in this case, yeah, the planning commission. So that was kind of my example with the comprehensive plan. So example, but let's just make it that. Let's make it the master plan, which, you know, is synonymous in certain venues and not in others. But in this case, let's just say it's the same thing. So yes, you have a responsibility to, research, draft, and adopt a master plan. That's one of those things that I mentioned earlier. That's an ongoing thing, and there is like a master plan schedule, and, you know, there's a lot more than goes into it than just the planning commission, which is why I still stress communication between staff and communication with the board of trustees, so they know what's going on with their advisory boards, and with the planning commission specifically. But yes, I would say in those sorts of situations, there would be nothing from stopping the planning commission from, in cahoots with staff, coming up, always having an agenda item, or asking, or just telling the powers that be that you'd like to discuss, you know, you need to put master plan on the agenda because you need to get to work. I agree with that. And I would call that, like, that's always there, right? So, but again, there is a cycle for the master plan and when it has to be adopted, who reviews it, and what that is. And so that's why it's important, of course, for to not be unilateral in nature. But of course, I think that the planning commission would have does have the responsibility to always be considering, you know, those things, especially as they become due, or well before they become due. So you're not scrambling to try to, like, pass a master plan in a matter of a couple of meetings, which is an impossible task. So, you know, to your point, you know, I agree. I think that, you know, master plan is one of those ongoing implied tasks that the planning commission would always have the authority to put on the agenda if they think they need to be discussing it. That doesn't mean that, I'm not saying that every agenda item is like that, but certainly the master plan is, yes.
I'm going to ask Chairperson Suzanne, your hand's up. Sorry, I'm getting too tired to get the right. Sorry, Suzanne, go ahead.
Hi. So I am thinking even more fundamentally. I mean, more than the master plan. I'm just thinking, okay, so historically we've had a really unschooled planning commission. I mean, over the past 10 years, you know, it's almost been laughable. They haven't known what they're doing. And there's just been a lot of ignorance around that. And for me, I'm just wondering fundamental, and they haven't been meeting, you know, they haven't met. But, you know, the statute says, talks about a regularly scheduled meeting, I think, every month. And so, I mean, it's like, what happens when you present agenda information, but your meeting is canceled? And my concern is I want to know what I think I would like to meet as a group and go over the process of you know, procedures we follow. I'd even like to talk to the rest of the members and say what day is the best for a regularly scheduled meeting, what time we want to meet. You know, I'm not into these doodle polls by email. You know, just have that face-to-face time, but we can't even do that. And so when you say the planning commission can meet, how does that happen? It's like, who is saying the planning commission is meeting? I mean, that's an easy thing to throw out into air as words, but what's the mechanics of that? How does that happen? Who's responsible for convening the meeting? And then I think it's really important to have that regularly scheduled meeting because you don't have to try to get a meeting on the agenda, or you don't have to try to get a meeting. It's just there, and you know every month what to expect. So how does that happen when you say the planning commission can meet? How does that happen? Oops, am I on the phone here? Okay, I'm sorry. It's hard being remote.
I think
hard
you
to communicate.
play a second. Suzanne, give play a moment.
Yeah, and I don't know if you were breaking up for.
Yeah. Did you not hear all that from Suzanne?
Yeah, I did. I don't know if she was
Okay.
breaking up for you guys too, but I think I understand the gist of the question, which is the mechanics of the planning commission meetings. Typically what I see, which works best, is to have a standing meeting. Depending on the amount of work that the planning commission has, you don't have to have a meeting every month, but you know, you should have a scheduled meeting. It should be properly noticed, and you know, then depending on you know, those notice requirements and other things that go along with applications, you know, the agenda is built kind of off of that. But my advice on the mechanics is that it should be, you know, that your planning commission meeting is whatever, the third Tuesday of every month, or if you have too much business, then you know, you meet the first and third Tuesday, whatever the case may be. Just keep in mind that the mechanics of that are important because the staff has to know when and how to do their requirements, because the planning commission might get an application, but that also might trigger staff to have to send out notifications, possibly develops a staff packet or not, staff reports. I mean, all sorts of things go into you know, the background, so to speak, of what you see. And so I always say this, it's good for the staff to know when the planning commission is meeting, because it will drive their battle rhythm for preparing and sending out notifications and, you know, helping set agenda items, because you might want to sit and talk on an issue, but the staff might not have, you know, might be a week later than the application in getting the notices out. And so, you know, they're not meeting their requirement deadline for, you know, 30 days notice before the public hearing or whatever the case may be. So the short answer is I prefer, for the same reason that BOT meetings are regularly scheduled, to have just a regularly scheduled planning commission meeting. Of course, the agendas are always going to be different, but it just really helps. I think it just helps with preparation.
So I wanted to, I mean, can we have a resolution that establishes when our regularly scheduled meeting is, or is that overkill? Because what I'm seeing is our regularly scheduled meetings are just being canceled, and it's not being canceled by the planning commission. So, I mean, is there some formality that we can have a resolution that says we resolved to meet, you know, this day every month at this time? And,
Sure.
you know, and we can
I was
always
under the
like
impression
not
that
approve.
that
Yeah.
existed.
No, we don't have a resolution for the, I wanted to see one, but we haven't even been able to meet to discuss that.
No,
So,
that'd be something
hopefully
that'd
that'll
be
be a
something that,
priority.
yeah, and that'd be
Yeah.
something the BOT could, you know, if the BOT wanted to do a resolution to submit for a regularly scheduled planning commission meeting, that's, you know, kind of their requirement to make sure that the planning commission is, you know, conducting their business properly as an advisory board. And I was under the impression that had happened or that was in effect, but if not, I think that's a good point that, you know, there should be something determined by the board that, you know, when and where the planning commission meets, for sure. And it should, again, there should be a regularly scheduled meeting. I was just under the impression that that was already happening.
Thank you.
So that could be an agenda item, and we work with you, Clay, on getting the basis for the beginning of a resolution.
Sure. Yeah, that's easy. I probably have one of those laying around. Yeah.
All right. Any other questions? Okay. Oh,
Yeah.
Trustee Brunner?
One more, and 3123-210. It ends within general, the commission has such powers as are necessary to enable it to fulfill its functions, to promote mutual planning, and to carry out the purposes of this part too. This is also where it says that the commission has the authority to enter onto land, leave monuments, that other officials shall respond to their requests for information, to promote the public interest in the plan, to publish and distribute copies, advertise it. So this, in general, has such powers as are necessary to enable it to fulfill its functions, to promote mutual planning, or to carry out the purposes of this part too. I mean, to me, that's kind of a mandate. Can you speak to that a little bit?
I guess I don't know what the question is or what we're getting at.
Well, let me rephrase it. How do you interpret this? In general, the commission has such powers as are necessary to enable it to fulfill its functions, to promote municipal planning, or to carry out the purposes of this part too. That's in statute. So how do you, or maybe you'd like to get back with us later on how you would interpret that.
Yeah, I mean, I don't know exactly. I mean, I think it's dangerous to take a particular, take a particular section of the code, especially in Title 23, and try to elaborate on what exactly that means. My interpretation of most of Title 23 is that you have, what they're saying there is that you have the authority to make these decisions, because because the challenge becomes, well, you're not the board, you can't make that decision. And these statutes are meant to first and foremost, it grants, all these powers to the BOT, and then through the BOT to the Planning Commission. And then that Planning Commission, in my opinion, that particular part of the statute in context is referring to the Planning Commission's authority to conduct all these, things that you're talking about. Like, they have the authority to, do what is necessary to make and, draft the master plan, for example, because we were already talking about that. So I think that's more of a Planning Commission empowerment. And I don't know if that's what you're getting at or not. Insofar that it is, I agree with you that the Planning Commission does have to have the authority to do the things that are delegated to them. if we're going back to the meeting issue, I don't know if that means making and setting your own agendas, because again, that, you know, if you're not in concert with the board of trustees, then you might just be spinning your wheels. But, you know, there seems to be some struggle between the, you know, where what the planning commission is doing and you know, what the board is doing, or something, you know, going on that maybe I don't have the context for. But I don't think that the planning commission should be operating unilaterally from the board of trustees, to speak plainly.
Okay. 4 slides. Oh, Clay, do you want to talk about this? Or I have to tell you, we are going to be getting really in-depth training from CIRSA.
Yeah, it's going to be almost identical to this.
29th and 30th. So, boy, I'd say let's not. If you're comfortable with, and you're welcome to sit in on that training to see what we're being told, but I feel like maybe it's getting late and we still have the master plan to talk about. So.
Yeah, and I'm told I am not. I know Sam Light and the guys at CIRSA and gals at CIRSA. They're great. You're going to see that most of this presentation was, you know, largely identical to CIRSA's, because that's, you know, what they encourage you to do. They're like, hey, take this, train your people. I've, you know, kind of tweaked it and manipulated it over the years to kind of go more towards, you know, what I like to focus on, and, you know, what I think is best for, you know, some of these small, because they have to deal with everyone, right? And so I've kind of keyed into what more of the, what I believe are issues I see in the rural, smaller Colorado towns. But anyway, I think I have no issue with that. I think it's great that you're getting more training. I think it's fine. All I have left is the ethics and conflict stuff, which CIRSA will go a little bit more in depth into. But again, you're going to get a lot of the same training. You're going to hear the insider, outsider, all that stuff. That's all very, you know, that comes from CIRSA. So, and I learned that, you know, 7 years ago when I started in municipal law. So, I have no issue with that. I'm happy to sign off and let you guys get on with the master plan.
Well, and I would hope you wouldn't sign off yet from the meeting. Oh,
great. No, if you want me to, I'm happy to stay. Yeah.
I think it'd be good if you remain, simply because you have not been part of our comprehensive plan process, and we now have a final draft. And I just want to say too, as our attorney, there'll be opportunity if you see something that is untoward, you will let us know in terms of ethics.
Of course.
Conflicts of interest. So
yes, ma'am.
Thanks. Thank you very much. So unless there are any more questions regarding planning commission, I'd like to say let's move on to the, sorry, yes?
I need some direction on this. I don't know if this is point of order or what. We have had information overload, a lot of arcane and abstruse information. And now, after 2 hours of that, you yourself commented that you were getting tired. Mm-hmm. And so after all that, I think the proper solution is not to add more information overload on top of the current information overload. I think we need to reschedule.
Well, I wasn't envisioning that this week, the consultants are not presenting. They're not. There's no money left in the contract. So I envisioned this just that we all have the final draft and we need to decide on dates for comments to come in, so there can, for the final, we need to create a schedule to continue with this process.
I inferred there was a long presentation.
No. Okay. Trustee Brunner?
I would suggest and move that the proper thing to do is to now send this to the planning commission and ask the planning commission to look at it and get back to the board with where the planning commission thinks it is.
And I thought that's what this meeting is.
And it's up to the planning commission to recommend adoption.
Well, I just want to say this was the reason we had a joint meeting. Because the hope was that the planning commission would be here to say, we've received it because it's in this agenda packet. And we need to make a plan. We need to have a date set for when comments need to come in. How are the comments coming in? We need to do administrative logistical things at this point.
Planning commission, it is my motion and vote is both here and in the planning commission. Is that, and maybe the planning commission won't second or approve such an idea, but I think it's time for the planning commission to sit down amongst ourselves and go through this.
And how would you want to do that? Because you're not
In a meeting of the
Just
planning commission.
amongst yourselves.
Yes.
With staff help?
It would be a public meeting, staff help would be welcome, but I think it is I think what we've just heard is that it's the planning commission's job now to consider what we've got and decide amongst itself what to do next.
Point of order, aren't we setting a date to send this to the planning commission and having send a date for public comments to be entered and then a date for final approval?
Let me just read what's in here for 1 second, just to be sure. Determination of process and timeline for adoption. Planning commission members and the board of trustees are to get comments to town staff for compilation and inclusion in the document provided as an attachment. All comments should be received no later than noon on August 2nd, 2024. Public hearing for final adoption by joint meeting of planning commission and board of trustees, possible date September 4th, 2024. So that's what is on the agenda. And I was hoping we would have planning commission members, and I appreciate that trustee Bruner's here and chair Watson. But I mean, I'm kind of at a loss because, I mean, I don't mind if the planning commission sits down and goes through it, but you will not have, you know, we don't have the consultants. They're no longer there's no money left to pay them. So you're suggesting the planning commission at its, when's August 7th is the next meeting? And there's 2 hearings.
I think, yes,
So you would like to,
I suspect that the planning commission would go over and above to meet to consider this because it is a matter of some urgency. I think everyone on the planning commission realizes that. I don't think anybody's trying to drag their feet or derail or anything like that. But I think it's important that we understand this before we recommend approval.
I'm just wondering logistically, so I just want to understand what you're proposing. So that
I'm proposing meetings of the planning commission.
Right, I understand that. But are you suggesting that all the planning commission will have read the copy and you'll talk amongst yourselves what you think is good and is not? Or because the planning commission has seen all the pieces and then we saw the combined draft that was this pre-draft. I'm just curious. I mean,
my feeling on that particular point is that I've read through this final a couple of times, and I'm not sure it bears a whole lot of relationship to the previous parts. This is the first time I think we've seen the whole. I would hope that the members of the commission would read it a couple of times before we talk about it. But if we have to read it in a public meeting, I guess that's what we have to do.
Well, I guess I would say that from what I've looked at in the previous draft, it wasn't that much different than the pieces. I just frankly couldn't read it in pieces and do a good job of reviewing. So I'm glad to see the whole thing. Do we have a deadline? I mean, we need to get this approved sometime, just to move forward as a town. So Stefan, do we have any deadline that you've been trying to
We
deal
do.
with?
We have a deadline as it relates to the grant that we received from the state to get this done. In order for me to get a final reimbursement, we do have some things that we would need to do.
Yeah, I just think we need all the information on the table because this can't go on ad nauseam. We have to have an endpoint.
Mayor Smith, I just want to say.
Wait, nope, come up here, please?
All right, we do have 7 hours left for a final presentation, if you guys should want us to do that. So that is a remainder that's still on the contract if needed. Very small, but it is enough to do a formal presentation or answer formal questions. So you guys know.
Thank you. Oh, are you looking at the contract or
The
grant?
contract we have with the state, yes.
Okay, looking at the grant. Okay.
Mayor, I appreciate having that information, and because what I would like to know is what our final deadline is for the grant, and what would happen if we don't meet that deadline. What sort of repercussions would there be for the town? And then that gives us the end point, and then we could work back and come up with timelines.
And so this was presented at our last meeting. It's the grant tracking spreadsheet. And you can see that the PO, the EIF A00232 POA comprehensive plan update, that deadline, that contract expiration is September 30th of 2024.
So we need to have an approved version by September, what was it? September what?
September 30th of
Thank you.
2024.
So it is now. August. We have about 8 weeks left. Okay, go ahead, Trustee Schwartz.
Town Administrator Lynn, how much is that grant for, and what would happen if we don't meet that deadline?
Yeah, so the total that we have received so far was $15,086.75 out of $25,000. And we have $9,913.25 left to draw from. Should we miss this and the state say for whatever reason we're not going to grant an extension, we would have to pay the state back a little over $15,000.
So what's the procedure for an extension?
I don't know. I'd have to ask them. And they have to agree to it. The issue that we have is that while we awarded a contract to our consultant in February of 23, the grant contract was signed in 22. So trying to get an extension, we've already asked for one. That's why it's September 30th of 24. We were asked for another one. I don't know if they would grant it or not. It's a question to ask our representative.
Could you repeat that? There was already a request for an extension?
We had to extend it, yes.
Do you know what the previous date was?
I don't have it on this spreadsheet.
Okay. So at this point, I'm gonna start reading it and make my comments, is what I'm gonna do, because that's what I feel like I have to do. I guess if the planning commission, if you have the, you have the buy-in of the other three, and you wanna have a discussion amongst yourselves, I don't know if you wanna do it August 7th, because there's already 2 hearings scheduled for that day, that evening, I don't know.
I think there would have to be some communication about scheduling amongst the members of the commission. And I mean, it's not up to me.
Well, and it's not up to me either.
But
Really?
I would think that a quorum of the commission that agreed on a date for a meeting like that should be able to hold that meeting.
Well, like I said, I was hoping we would have that tonight.
Yeah.
That was the whole point of this joint meeting, so I'm
disappointed.
It's unfortunate. And I know Lynn had I don't know.
She sent me some messages.
Okay.
She was truly an emergency.
Is everything going okay? Yes. And Suzanne, you have your hand up, I think?
She did.
Oh, I don't see it.
Yeah.
There it is. Okay, go ahead.
So this is why, I've been trying to get the planning commission together, beginning with our regularly scheduled meeting that was canceled. Because of I have a new job, and because of my work schedule, I really need to, being able to meet in person is it's important to me, and I think we need to look at the day and the times that we meet. And we haven't even been able to do that, and yet we're talking about having to adopt the final draft of the master plan in 1 month. We have never had resolutions for the planning commission meetings. It seems that should have been first before any of this should have started. And now I don't like to feel this pressure pressure at the very end when we haven't done our due diligence at the beginning. So to me, because like today, 10-hour day, tomorrow, 10-hour day, including a huge commute back home. The middle of the week is hard for me now. So I really would like to talk about other weekdays that might work a little bit better. And this doodle poll, I just don't see that as being very productive. But I know we have a regular meeting scheduled or a meeting scheduled for next Wednesday. That Wednesday was the last planning commission like that day, although they had a much earlier time. And I can meet for that. I've made sure my work schedule is not going to interfere with that. But, I really think we need to talk about what the best days are for meeting and when, look at everybody's schedule and see what we can really do. It's really important.
I think the open meetings law specifically allows email communication regarding schedule. And so I think that the planning commission should undertake to schedule a meeting under that portion.
I would suggest that be done with staff.
We could do it through staff.
Yeah, no, staff should be sending and asking for.
Well,
names.
there's a specific exemption in the law for that. We
just-
can do it through the staff. But I think
it would
we need to undertake.
I think it would be better to do it through the staff because not everybody's reading their emails and the staff will know if they're not getting a response and they can call.
And so like this day was scheduled.
That's what I thought on Wednesday. We could all talk, we could agree on next.
Well, the next meeting is the first Wednesday of the month, which is August 7th. But I don't know I think we are on shaky ground. If you're waiting, I'm going to start reading the thing.
Oh, no,
But if you're going to
nobody's suggesting waiting for anything.
Well, no, so your desire is to have the whole commission together to talk about it, which would make sense to do it on August 7th, your first scheduled meeting.
If not sooner.
If it's a Wednesday.
But you do have a quorum of planning commission members here tonight. You have one, virtual, so you could.
Two?
Oh,
well, I count them.
Yeah, you count as well. So that's just ex officio members count. You could decide if you want to have a meeting between now and the 7th.
Meet next Monday.
Who's got a calendar? Hang on.
I believe Commissioner Watson could be there on Mondays.
Hang on.
She can correct me if I'm wrong.
So Monday is the 22nd, right? I don't want to be there, but I could be there. I'm going to be honest.
All right. Tuesday's town council.
Yeah, and Tuesday night is our trustee meeting. Suzanne? Oh, Suzanne, are you muted?
I think you hung up on me. Are you there? Can you hear me?
Yeah, we hear you.
Okay, so you're saying next Monday?
Hmm?
Next Monday, yes?
Yes.
Yeah, I can be there next Monday. Mondays are a day that, it's not ideal, but it's a day that I know where I'm at, and it's there in Paonia.
6 o'clock?
Yeah, that would be fine.
And so will staff notify the other 3 members? 2 members, sorry.
I just want it to work for them too, but.
Well, that's the problem.
Yes, well, let's consult with them.
What are you thinking?
Don't we have to notice it?
It has to be noticed.
So.
Wait a minute, it's.
24 hours.
What's today? Yeah, it's this time.
We're finishing the packet for the 23rd meeting tomorrow.
Oh, yeah. It'd have to be tomorrow.
Yeah, we have to do it tomorrow.
So the 3 of us, if they don't show up, we still have a quorum. But you're not really are you thinking you want to have a discussion about it? Perhaps have the consultants there to answer questions?
Be good.
And then there needs to be a deadline for comments created. Right
Okay.
now, there's August 2nd on the table. That's not very far away. That's on the table. And
We don't have many hours left for the consultants, so, and we haven't asked if they could be available on Monday.
Perhaps the commission could, at a meeting, a public meeting, actually come up with some of the commission's questions. They could then be put to the consultants, so that we're not burning their remaining time listening to the commission deliberate.
or put it in writing.
Yeah, exactly. I would guess it would be by motion. We're gonna ask these questions.
Right, and I would do it in
Or
writing.
we have these concerns.
So, I would suggest you not getting the answers, I don't know. Do you want the answers publicly, or do you want it,
Oh, and
do
I'll
you want it
ask-
addressed in the document?
So the way that we've done this process before, we did it for the housing needs assessment, was we asked for feedback from the board to send those questions to staff with those edit requests. We put them in a spreadsheet that looked just like this. You guys just sent them to me, I put them in there by page number, where this paragraph or sentence began, and then the comment or question or the requested edit, and then who did that, who asked that credit or that request. I mean, we've done that process before, it worked, and that's it's in this packet to say this is a similar process, to really cut down on hours, to really help organize comments. And this is all public information. It was public information for housing needs assessment as well as published on the website. So
probably the difference here is we do not have the consultants updating unless we save their 8 hours to update the draft. Otherwise, staff is gonna have to update the draft based on comments received.
we're gonna do a change order.
Is that?
We're gonna do a change order.
I mean, it's kind of up to what the commission decides, like I said.
Well,
It's not up to me.
right, but
But I think the commission has to go through a step like this.
But I'm bringing up the logistical piece of this. And that is that the final draft has to be created based on comments received. The staff it's gonna have to be staff doing it because there's not enough time left unless there is a change order. And we also have a very strict deadline that it sounds like we kind of need to make by the end of September to adopt it. So I'm just putting that out as the reality here. And everybody needs to read this. That's the bottom line. If you have commissioners who come on Monday and haven't read it, I'm sorry for people, what are you doing then? So I think the point of this meeting was to say, we have a drop dead time to submit your comments. There can be a meeting between now and that August 2nd, but in order to try to get a final done by the end of September, I would recommend that August 2nd comment deadline stay, and the commissioners can meet on the 22nd, talk about it, and then get their comments to staff by the 2nd. And then there's time for the draft. All those comments have to be looked at and sorted through. And then the draft has to be updated, and there has to be kind of a statement of reasons that's in this that says whether the comment was accepted and it was changed, or the comment was not accepted for this reason, which is very time consuming, but that is the public way you do a document like that. So I'm just talking timing and logistics.
Let's get busy.
So can we agree on a comment deadline? And Trustee Schwartz, you have your hand up, sorry.
a comment deadline and the spreadsheet. I mean, it's like, I think that has to be part of the motion. If we're going to just keep this moving forward in an organized way, let's use the spreadsheet.
Yeah. Which is in the agenda pack, and it was asked for, I think, somewhere in there, but yeah. And can you upload that and turn it into a fillable form? Because I think it's in PDF in the agenda packet, right?
It is.
Is it in a fillable form on the website?
It is not.
Can you do it?
As being the person that has to compile all the comments, trying to take multiple fillable forms from people is gonna be difficult.
What would be the best way to do it?
To send me your comments in an email or in some form of writing, and I can put them into the spreadsheet. That's what we did with the housing needs assessment.
And that's from everybody, the public? Because right now, the public doesn't have
Yeah,
a deadline either.
right, the best way is in an email or a Word document, that way I can copy and paste.
Yeah.
And I'm not trying to type out the comments.
Okay.
So if we're gonna set a deadline and actually try to stick to it, I would suggest that we should plan on more than one meeting of the commission to consider this. This is a very important document. This is gonna be something that the town's gonna be trying to use for many years. And I don't want to be that rush. I think that we should at least have a second meeting scheduled after the public hearings, which hopefully they won't be too time consuming. And deadline for comment should be at least several days after that meeting.
Which meeting are you referring to?
The one that's scheduled is at the 7th.
Monday? Or August 7th?
Yes, I think if we have a meeting on the 22nd, I think we should also figure on having another meeting for planning commission discussion of the plan, also on the 7th. A deadline for comment should be sometime, some reasonable time after that.
8th? I'm trying to get this, because
You know, my own feeling is that if we have to appropriate a little bit more to make this happen, I mean, our budget this year is $16 million.
But there have been numerous meetings on this. It's
Yeah.
not as if there have not been meetings in
There
front of the
has
planning
not been a
commission.
single meeting where the planning commission did discuss this amongst themselves.
They absolutely could have at every one of the meetings when the pieces were given. So I'm just saying.
No. We were
yes.
given a 3-minute speak within.
You've only
which
been
to
on the
comment.
planning commission since there
How
were
long
meetings.
have we had the final draft? Excuse me.
No. The pieces were provided there have been multiple meetings where the sections were provided. So the commission at the time had every opportunity to ask questions.
This is the commission at this time.
Right, and I'm saying, so please do not act as if there's not been work done up until the point where you join the commission.
I
So
don't
let's
mean to
move
imply.
forward.
I don't
We
mean to
now
imply.
have a really nice, consistent, single document to look at. And I'm gonna start reviewing it and submitting my comments. I don't need to talk amongst the commission.
I've already
but-
in the process.
But if the commissioners at the July 22nd meeting, I think it should be up to them if they want to discuss it more.
Okay,
So that would be the time to say whether you want to bring it up again on the 7th.
okay.
But in the meantime, I encourage everyone in this room and listening to please begin reviewing it and sending comments. And I still think we need a comment deadline, because for Stefan to take comments and put them in that, depending on how many comments are received, is a huge task. So time is of the essence. And I'm not.
So
Yeah.
I've asked for a tablet. I've asked for a tablet that maybe we could have this plan downloaded on it for me so I can make electronic comments on it or in a Word document, because all I can do now is handwritten and it's very difficult.
Clay, could you address the giving town property to a citizen?
Yeah, town equipment for a planning commission member to do their job.
I'm gonna let the attorney address that. Clay, if you're still here.
Okay,
yeah, I'm
it's
still here.
very hard to make comments for me.
There's nothing, I don't know how much of it is a legal question. There's certainly no requirement that the board provide computers to commissioners and
No, there's
advisory board members.
no requirement.
But insofar that the board, it's really just a board decision. You guys, if you have the resources and do you want to provide your planning commissioners with, I've seen towns that only do it for trustees. I see boards that can't afford to do it for trustees. I see towns that and, you know, everybody who's a member of an advisory board or commission gets a, you know, gets some sort of device. I mean, it's really just up to you all, but there's certainly no requirement that you do or you don't do it.
Okay, well, we need to do a policy because there's security associated with using town devices that has to be followed or they can't be used.
Sure. Yeah. I mean,
So
if you do issue town property, you know, there are certain things like there has to be town software on it. You have to have, you know, you have to have certain, you know, limitations. It can only be used for, you know, town business. You know, all communications have to go through town email. I mean, there certainly it's not just like a,
Right.
I was just discussing the actual like
Sure.
logistical implementation of giving devices, which really is just resource driven.
Okay, well, that would be,
We have them. We have used devices.
I don't know that there are devices at this point, that will have to be answered. So hang on one second. So, Suzanne, at this point, the board would we need to have a policy put in front of us to do this.
Okay, well, think of that when you think of the final adoption date then.
Yeah, and so Trustee Schwartz, let me let you have a chance.
Yeah, I just want to say, Chairperson Watson, we have a really amazing public library with free computers. I think that this is.
You know what, Trustee Schwartz, I work from 7 in the morning to 5 at night. I get home at 5:30. The library is usually closed. And I try to go to the library during my lunch break in Hotchkiss, but often, you know, you only have a half an hour on the computer. It's really hard to do things because there's usually a line too.
And Trustee Brunner?
3123-205, staff and finances. The governing body shall provide the funds, equipment, and accommodations necessary for the commission's work. So I would think that a vote of the commission that the device is necessary would be pretty much the decision.
I think it has come from the Board of Trustees.
It says that the board shall provide
Right.
funds, equipment, and accommodations.
But it has to
necessary.
come from the board. So
Right.
to me, it has to be a
So-
policy because we have security issues. It's not just a matter of handing a town device. There are many security issues that we have, including phones, you know, our IT people. So it's just not that easy. And I am.
You know,
So we can try to get a policy on the next.
And we did just previously approve email addresses, for planning commission members. That was a long-term request of Chair Watson. And so we did provide those. As far as devices, as I've explained numerous times, those devices were collected from outgoing staff members. They hadn't been wiped yet. They are currently with Phones Plus so that we can get any important information off of them and have those devices reimaged. It's not my decision to make on who to give these devices to. That has to come from the Board of Trustees.
We had trustee tablets at one point, and that's what I was thinking of. I don't know what our policy was at that time when the trustees had tablets, but they didn't take them home. They should still be at town hall there, the trustee tablets.
Suzanne, the tablets have all been gathered. So what Stefan just described is what's going on. So at this point, there are no tablets to give out because the ones that were unused are having to be cleaned, wiped. So at this point, we don't have one. But what I'd like to suggest is, let's put this on the agenda for the 23rd as a discussion point and a motion to be made about.
Because I can continue to do handwritten if you want, but.
Well, we still need, we have other things to talk about in terms of email addresses too.
And I did take handwritten notes from the housing needs assessment as well.
Yeah.
The couple trustees.
Right, so Suzanne, handwritten would work. I know it's harder,
It's
but
very difficult though, let me tell you, handwritten comments, it's really, I'd rather have meetings of the planning commission where we can jointly meet to talk about the comprehensive plan than all this random individual commenting. I just don't think my handwritten things have been considered. And it's very hard to do handwritten things because of the edits that you have to make. You have to do scratching out and whatever. Very difficult.
Okay, Trustee Stelter?
I'd like to set some dates. We already have the 2nd and 7th for the planning commission. I suggest that we put down the final comment date as the 9th. And that gives enough time for those to come to the town board. And then I just lost it. The town board meets, and the planning commission should have a recommendation for approval by the town meeting. The second town meeting in August. And then we meet again, or we can approve it at the second meeting, or if there are further questions, the first meeting in September.
So we're talking August 13th is the August 13th and
Comment date.
27th. I'm just saying are the two trustee
Right.
meetings, just so we have that out.
Right.
And
the 27th
is
would
the
be the-
second.
That would be the date for the town council approval or presentation of the final draft. And then approval on September, lost the page.
10th.
The 10th,
Right?
yes.
Yes.
And I can make that as a motion if you'd like.
Yes.
I have a question for staff, just on the, or maybe for you, Mayor. On the agenda with the possible date of September 4th for the public hearing for final adoption. I'm just curious why that date was on there. Was there a reason?
It's the regularly scheduled planning commission.
It's that first Wednesday in September. So in other words, we would, but based on your potential motion, we would move consideration of it on the 10th and adoption on the 24th.
That's correct.
Moving it up to August from September.
No, that is September.
September.
Yes.
And then a final adoption on the 24th. Things going well, mean it could be we could codify it. That'll be, what do you do with the master plan? It's not codified, it's just accepted.
So that's the reason for, it's got to be adopted.
Yeah.
And that's in our it must be adopted. It can't just be accepted like.
Right, so it has to be adopted in order to fulfill the grant.
Fulfill the grant.
So the 24th is the drop dead time to adopt it at a regularly scheduled meeting.
Correct.
Is the proposal. Is everybody getting that with their calendars?
So, point of clarification. Is that adopted by the planning commission or incorporated into the town's zoning regulations?
That is adopted.
It's not zoning.
So it's adopted by the planning commission.
It's adopted by resolution, and it has to be adopted by the governing boards of anything that plan touches. So not only does it have to be adopted by the board of trustees, but I then have to get it to the county for their adoption as well.
Does that have to be done for the grant?
It does not. We have to
Okay,
adopt it.
okay, good, shoot. Okay, I mean.
I'd like to see this grant. Sorry.
You get your dates straight.
Yeah, I'm trying to, making sure that I can get them all.
And I have that you wrote comments in by August 9th.
Let me get back to August here.
Okay.
Hang on a second.
Would my paper calendar help you?
No. Here we go.
Madam Mayor.
Yes.
Well, trustee Stelter is figuring out the date or revisiting that. One thing that keeps coming up in my mind is that, I mean, I understand that the planning commission, they have to adopt this. I'm also very hesitant, leery, concerned that 3 to 5 people could potentially overrule hundreds and hundreds of hours of public comment and all of the public work that has gone into this. And I just want to say concerned, because it is something that so many townspeople, so much work, so many comments have gone into this. And to put that type of power into the hands of a public commission or a planning commission does, and I get that this is just what we have to do, but it's something that I'm very aware of.
Are you looking at the code?
Well,
Go
I
ahead.
just had a
Mhm.
question in that same vein, in that the planning commission should absolutely review it and offer comment, review it as a body and offer comment along with everybody else by what we're proposing the deadline to be on August 9th. But the adoption is actually by resolution by the Board of Trustees, not the planning commission, correct? So the planning commission would be offering comment.
Can we ask Mr. Attorney to clarify that?
You guys good? Well, I mean, so here's the deal with the master plan, and here's the deal with all this stuff. It seems to me like there's some sort of like the planning commission and the board of trustees, should be working together in the master plan. The master plan, the statute, basically delegates that authority to the planning commission to to draft and adopt a master plan. But it also, in the same vein, says that it has to conduct. I mean, I don't have it in front of me. It's an immense piece of the statute, and 3123, 200 plus. I'm trying to think of where the exact. There it is, 206. So, and as you all know, it's a long range. It's a document to guide long range physical development of the community. I see where the language says that the planning commission, shall draft and adopt a master plan, but the master plan is really, and I agree with the comment, it really isn't. It really has to do with whatever the process that goes into it. So if you read along the lines of the rest of the statute, I can't find it right now. It also says that the planning commission will conduct, will take public comment, will conduct surveys, will, do all these things. And that's not necessarily what goes into all of it, because there is, as we discussed, like some very real funding, resource requirements, et cetera. But anyway, to get down to the point, my point is that, the master plans should eventually and or at the end of the process be codified in some form, either a resolution or whatever, be adopted as a document that the whole town adopts, and that's done eventually by and through the board of trustees. I know the planning commission can adopt and do whatever they want, but at the end of the day, the board of trustees can can overrule that and or and or also adopt and implement whatever the planning commission advises and or comes up with. But ultimately, at the end of the day, it is the board of trustees' decision whether or not they want to leave the master plan to be I would say adopted solely by the planning commission, or whether they want to adopt it as well. It seems to me not to serve no purpose unless the entire town is in agreement with it and is willing to use it as their long-term guiding plan for development. And so, I mean, what I see typically is that the planning commission works in concert with the BOT to conduct the surveys, do the notifications, do all the things required to intake public comment, and then the and then it's eventually adopted by both the planning commission and the board of trustees. Although I at the moment can't find a statute where it says that's required. It just doesn't make sense that it wouldn't be.
Well, I think you just said it, Stefan, when you read the boards that it affects.
Correct.
Which
Whatever
was-
the plan affects, those those governing bodies must only, the planning commission gives a certified copy of the plan to those boards, and they have to approve it as well. They have to adopt it. But this has been a joint project since the very beginning. And I keep pulling up the screen because this is the process that we took. It was very intentional to include both the planning commission and the board of trustees in this entire process, to the point where we may have overkilled it by taking public comment, but it was the amount of comments that you see in your packet tonight. The majority of our packet are public comments, written public comments, and I think that's really important to know how activated this community was and how active they were in designing this master plan. And to answer a question, because I get it, trust but verify, there's the expiration date for our Paonia Comprehensive Plan update. This is the DOLA Grants Portal website, 9/30/2012.
Thank you. Right, so trustee Stelter, how you feeling about your dates?
I'm good with those dates.
You want to say?
Could you let me read them off of your notes?
Yes, I will. And I just want to point out, I was just looking up the 1996 comprehensive plan just to see how it was adopted. And it is listed as a resolution number, and trustee Stelter signed it.
Yes.
I was on the board with planning board that time.
So you had said comments by August 9th. Why do I have August 13th and 17th?
Yeah, that's that. Those aren't right. I don't.
No, I think it was the next town board meeting.
Next time.
The 13th, August 13th is the next one. And were you thinking that it would be presented?
That the final draft would be presented on the 13th. And the final vote would be in the last
Oh, and actually, I think
adoption.
we were talking about 13th and 27th are the board meetings in August. And then September 10th
September
is the
10th
next-
is the adoption.
as the adoption. So there conceivably, the discussion could be moved to August 27th, adoption on
However,
the
the
10th.
planning board wants to meet, they can set meetings, and as long as they're noticed, set agenda, they can meet as often as they'd like in between them. But the comments still have to be in by August 12th, right?
You had said 9th,
9th, I'm sorry, I'm on September. Yeah.
which is a Friday.
It's a Friday. That gives the town staff an opportunity to get them published by the 13th.
Ooh,
Close.
no, I don't think there'll be time. No,
No?
it will take time to put all those comments into a cogent tabular format.
So we'll
Right?
have to push that.
And I'm happy to help. And I am happy to help do that.
We'll have to push back the.
Yeah, so that's where the
final
27th
Draft.
could be on August 27th, It
Yes.
could be brought, final draft could be the trustees by the 27th, which means all the comments have to be compiled by subject and put into that table, determined whether they are incorporated or not, and a description given where they were incorporated or why they weren't, or why they are incorporated in a certain way, which is a lot of work. I just have to tell you.
So what I did with the housing needs assessment, I tried, if I got multiple comments on one particular page, I tried to put them in order of page as well, so that does take time.
So do you think it's conceivable if the last day for comments is on the 9th to have a draft to, and it should probably be another joint meeting of the trustees and the commission to look at that draft and discuss it. I'm just thinking out loud now. Well, ultimately, we know we need to adopt it by September 24th. So how much leeway do we have between then to work on it internally and then get it out to the public for discussion? Would it be better to have a joint meeting the week of the 9th of September between the trustees? Because there's let's see, September, we have a meeting on the 10th and the 24th. To have a joint meeting of the trustees and the commissioners to look at the staff created draft. And then make any final changes and have it go. And the commission has to approve
But
it.
there's already a regularly scheduled meeting for September 4th, the planning commission.
That's right.
And as of right now, I have no applications for any sort of
That would drive.
business for that meeting.
Or you
I'm
suggest.
really trying to cut down on staff going to late night meetings.
Sure.
I'm kind of concerned about one on Monday, this upcoming Monday with one right after.
Having a.
Knowing that when I got here, I knew that there would be a maximum of 24 meetings a month that I had to attend, or 24 meetings a year. With there also being the possibility of additional 12, so 36 for planning commission. And we've blown that out of the water in July. So, I mean, that's something that I have to be cognizant of. It's not just my time, but also I've got staff here as well, in case there are any questions. So
Right.
I just want to put that out there.
And I'm sorry to interrupt you here while you're doing your logistics. I just want to point out, I knew it was somewhere there, and it was too close to the beginning. The reason that the reason that the Board of Trustees has to approve it as well is because it's in the statute. It says right below that the commission has to make and adopt the master plan, but then it says that master plan is subject to the approval of the governmental body having jurisdiction thereof. And so that's the Board of Trustees, and that's why the Board of Trustees has to approve the comprehensive or the master plan as well. Just wanted you, I knew there was an authority line there. The way that it was, I just kept kind of glossing over it because it was too close to the beginning. But anyway, that's why Board of Trustees have to approve it as well.
Thank you. So the thought is, if there's already a meeting scheduled first Wednesday of the month, to have that be the time for the revised draft to be presented.
That's the 3rd.
It's the 4th of September. So the thought is that would be when the revised draft, which includes changes made in response to comments provided to the commission. Works for me. I'm just,
I can make it work.
But that, if comments, or the deadline for comments is the 9th, that allows 1, 2, 3 weeks. And it should get in an agenda packet. So it really allows 3 weeks, because it probably should be published on the 30th for the meeting on the 4th. So that allows 3 weeks to compile all the comments and determine how to change it in response to the comments. It's kind of 3 weeks of full-time work. I'm telling you, I used to do this for a living.
Yep.
It's full-time work. I'm willing to help. And I don't know, Stefan, what you're.
Just knowing that also on the 13th is the Board of Trustees meeting. I've check runs after that. I've got a good staff that can handle those things.
Exactly, so you can't.
This would not have been possible if we didn't have the staff we have. So.
What if we move up the deadline for comments to back to it? Well,
I mean, this is why I had suggested these dates in the agenda packet. It's because knowing that there's a lot of work, and we are working with the deadline of September 30th. So, I mean, I don't just, when I make recommendations, I don't just arbitrarily make them. There are reasons.
well, if the commissioners are meeting on Monday, if that can be agendized, just it has to be agendized tomorrow. Yeah, and can it just be a cut and paste from this?
I think what would be really helpful is if I had the language for the agenda, so I'm not trying to go through this recording and figure out what the language for that agenda needs to be. So If it's just copy and pasting what's on here right now to put it on the 22nd,
Great. And then attach everything that's attached to this. Trustee Bruner, would you want it to say other than what's on item number 3 of the agenda we have tonight? With some adopt dates?
Review it here.
Actually, it's probably more of a discussion. I think it would be a different agenda item. It would be a discussion amongst commission members of the attached draft.
it's going to be really helpful.
Yeah,
Would that be good enough?
that sounds excellent.
Discussion.
Pretty good to me.
Discussion amongst commission members and public
Yes.
and
Unless it'd be an executive session.
public.
I don't think that's one of the reasons you want.
You can't do an executive session for the commission. They can't do an executive session.
Oh, I think
Discussion amongst commission members and public regarding the final draft of the comprehensive plan? Is that?
Okay.
I mean, I'm looking to you because this is your request. I don't want to put words in your mouth.
that's what I asked for. Yes, it's accurate statement.
Okay, so I'm a little confused because I thought tonight I was really looking forward to this kind of final presentation that we were going to have as a way to go over things. And now it doesn't seem like we're having this presentation because you kind of changed the agenda to be heavy on another item. And so this presentation of the final draft of the comprehensive plan didn't happen tonight.
There was
And
no
now we're jumping
presentation.
into comments.
Suzanne, there was no presentation to be made. It was simply the fact that you have it in the agenda packet to look at.
I
Because
mean, I'm looking at the agenda
consultants-
item and I guess,
That's the consultants we would have put presentation by consultants. But we only have 6 hours left in their contract, so we need to use it judiciously. So,
Presentation of the final draft.
right,
Agenda item number 2.
right, because it's in your agenda packet. It's being presented to the public in the agenda packet. Yes, trustee Hunter.
May I make a motion?
Well, hang on.
A motion is always in order.
Yeah, is it, we're still looking at dates, but do you have a motion that's outside of choosing dates for
I
comments?
can make my motion, see if I get a second.
Okay, go ahead.
Okay, so I move that we set the comment deadline no later than noon on August 2nd. And we set a joint meeting of the Board of Trustees and the Planning Commission for September 4th.
I second.
what day is September 4th?
It's a Wednesday.
Isn't that the regularly scheduled planning commission meeting right now?
Yes,
And you've taken away our regularly scheduled planning commission meetings for the last, 2 months? And now you're gonna take this one away too? I mean,
why are we?
don't we have an
taking away?
agenda for the planning commission that includes a hearing,
Order?
don't we have a land
Sorry.
use?
This is the motion for the Board of Trustees.
Yes, sorry, you're right. Sorry. Point of order. Yes,
So I think
okay.
there's a motion in a second.
Any more discussion amongst the trustees?
I call the question.
Takes
a second.
You got a second? Did we get a second? Okay,
Yes, so-
did you get the second? Thank you.
What is the motion?
Do we, all comments should be received no later than noon on August 2nd, and we set a joint meeting of the Planning Commission and Board of Trustees for September 4th.
Have a second? Oh,
We had a second.
Point of
Discussion?
discussion or clarification? Does that then mean that there's no substantive thing for the planning commission to discuss after the comments are received?
That's up to the planning commission. You can set a meeting anytime you wish.
Okay, so which the comments that are affected by this deadline are?
So again, this thing has been reviewed, re-reviewed by the commission, the board, and the public. We have a deadline, it needs done, we have staff recommendations for the best dates to do it. We're sitting here spiraling. We have 5 minutes left before we need to extend the meeting, and I wouldn't be in favor of that. I would just like to get this done. That's where I'm at. I mean, it's an important document, but it has been reviewed ad nauseum.
So
All right, all in favor?
I,
Okay.
opposed?
Got that? All right,
I was opposed to, I don't think you heard my vote because I'm muted.
not on,
This is a joint meeting. This is a joint meeting. I'm sorry.
Hello? Did you hear my vote?
we did not.
Hello? Someone muted me. I'm opposed to that. I don't think the planning commission has had ample time to discuss among itself.
Sorry.
And all this talk about there's been all these meetings, that's just what you say, but it's not really true. The planning commission hasn't really had meetings.
Argumentative.
Yeah. That's, the motion's been passed and we now need to talk about, we've got an agenda for their meeting on the 22nd.
We have a.
And you'll just attach what is on this agenda packet. And you will the staff let the other two members make them aware of it?
Yes, we will.
Okay. And is there anything else for the 22nd that needs any staff direction?
Just that we've got that one item, and I think that's enough. I think we can contact the other two planning commission members.
And this room is available.
We have had some ditch companies doing their annual
Right.
meetings, so let's check.
And
Do we have public comment on this?
what date? Sorry.
The 22nd,
Monday the open.
we're good.
Okay, we're good. All right.
Can we review the dates now?
August 2nd for the comments to be submitted to staff, and that will be put on the website with where to send them. And the updated draft will be presented at the September 4th joint meeting of the planning commission and the trustees. Is that what you had? Okay,
And then final draft to board September 24th.
we did not choose
We didn't
that.
get to that.
No, we can choose
Comment.
that later. Okay.
Why don't we go home?
Yep. And you're good?
You
got it.
I think we got it.
Between the two of you, okay. This meeting is adjourned. Thank you, everybody. Thank you, Clay.
Thank you. Good evening.